May I please your lordship? Lordship, I beg to mention item number 3 to 6, my lord.
3 to
6, my lord.
yes.
Due to health issue of my senior, my lord, he is suddenly in hospital, my lord. So, we will pass over the matter for the day, my lord.
They informed me last night only, yesterday evening, so.
Yeah, otherwise, there's no mention sleep on this.
Yes.
Who's your senior?
SCB shows, my lord.
Okay. On
In-
request made on behalf of SC Business. Council appearing for the applicant in criminal appeal 94 of 2016. List the matter after 1 week.
On it.
Not.
Obliged, lord.
May please, your lordship. I beg to mention item number 11 to 14, my lordship.
11 to 14.
This matter kindly adjourned for
CBI.
today may be taken on Tuesday, my lordship, due to personal difficulties of my senior, my lordship.
Who's your senior?
P. Kotoki, my lordship. Item number 12.
Well, you could have given your mention slip yesterday and informed the other sides. Who appears for the CBI?
I'm on behalf of Mr. M. Haloy.
11 to 14.
11 to
14.
I'm appearing on item number 13. Lord. Item number 14. I am appearing item number 14.
okay.
For the item number 11. Next.
Next, item 11, you are Mr.
Pablo Chakma Lordship, appearing on behalf of S. Borgohain Lordship.
Okay, just like this, on request made on behalf of P. Kataki, London Council for the appellant in criminal appeal 245 of 2016. How much time do you require?
Tuesday.
List the matter after 1 week. Yeah.
Can it be Lordship after 2 weeks, Lordship? Can it be, if
Up-
possible?
up to 2 weeks.
May I please, your lordship? Lordship, I beg to mention item 2, lordship,
Yes,
which considers the other side, lordship. Lordship, kindly adjourn the matter for today, lordship.
your MS
K. Malakar, lordship.
on request made by MSK Malaga, London Council for the appellant. List the matter after 2 weeks,
After 3 weeks, lordship, kindly.
3 weeks.
Lordship, must please.
May I please your lordship? I would like to mention here for an unlisted matter, case number 249 of 2022 with IA 605/2022. Kindly list the matter for Monday.
Why Monday?
Sir, your lordship, it is possible for tomorrow. You can list the matter for tomorrow.
Why do you want it on Monday? I must do.
Actually, my senior is out of station. She will be reaching on Sunday. That's why. Highly obliged.
May I please, Lordship? Lordship, I would mention item number 7 and 8, Lordship.
Yes,
Lordship, my senior, Mr. S. Borgohain, is out of station as of now, Lordship. Lordship, I have took the concern from the other side of the Lordship.
items 7 and 8 separate orders on request made on behalf of S. Borgo and Council for the appellant. List the matter after
After 2 weeks, Lordship.
same order, item 8.
Obliged, Lordship.
One of the list hearing.
May I please, your lordship, my lord? Basically, my lord, the defense side has argued on, my lord, 3 points, my lord. 1 point is that 164 statement which was recorded not by following the procedure of law, my lord. Second point is that section 27 was not followed properly. And third point is there is some defective investigation in this case. For all this point, my lord, he has argued before this honorable court and paid for a acquittal in this case, my lord. before going to them, my lord, I have to go into the, my lord, some part of the evidence, my lord. Your lordship kindly come to the, my lord, first PW1, my lord. He is the, my lord, informant of the incident case, my lord. Lim compare page 13 of the paper book. In that statement, my lord, I read one thing, my lord. He saw that I have seen passing human toward the jungle nearby, my lord. Page 14, my lord. First paragraph, bottom part, my lord. Then, my lord, police has observed the procedure, taken the dead body of my lord hospital. When the postmortem was done, I had taken the body village. After observation of the 23/12/2020, I was asked to bring my sister-in-law for interrogation. Accordingly, I called my sister-in-law, Mao PS. On PS, I have came to the police as Suman Biswas, who is the driver, is good relationship with my brother. I came to know my knowledge. Then your lordship kindly come to the next paragraph, my lord. I have also came to know that my brother was killed by accused knife. The accused person has disclosed that he has thrown the knife mobile my brother at the place. As per disclosure of the accused, Suman Biswas, police has recovered the blasting of knife and mobile brother from the jungle PO. On the basis of the disclosure statement of the accused person, the police has recovered the knife and other thing from the jungle, my lord. Then, my lord, your lordship kindly come to the, my lord, PW4, my lord. PW, my lord, 5. He is the one, initially, he is one of the co-accused, my lord. Subsequently, he made an witness in this case, my lord. His 164 statement has been available, my lord. This 164 statement has been never denied by the, my lord, by the accused persons, my lord. As well as, my lord, I have to come, my lord. No suggestion has been made that he was produced from the police custody, my lord. And thereafter, my lord, statement has been statement has been taken. Second point, my lord, he has not made any, my lord, made any suggestion in this case, my lord, because I have some authority, my lord, that is why I am submitting. The reflection of time was not given to the properly, my lord. Even, my lord, he has not given the suggestion, my lord. PW5, I am reading with PW5 along with the, my lord, Suman Biswas 164 statement that he was tortured at the time of recording 164. No suggestion has been made. And here, my lord, in the instant case, when it was PW, my lord, 6 and PW8 has said that he was produced from the judicial custody, no suggestion has been made from them, my lord, that he was not produced from the judicial custody. Meaning thereby that evidence is admissible in evidence, my lord. I am coming authority later on, my lord. Before that, my lord, my summary has been given, my lord, introductory part, my lord. Your lordship kindly come to the PW5 statement. The accused person standing on the dock is Suman Biswas. He used to work as a driver. After my husband purchased car, he taught my husband that whatever he used to go for. On the day of incident, Suman Biswas called over my phone and inquired, where is my husband, my lord? This is one of the circumstances. The Suman Biswas on that particular day inquired, where is his husband? As described, then my husband went to the office. As my husband went office, I proceed to my office. When I was at my office, my brother-in-law who used to reside called me, asked me receipt for Naukat, as while near there had crossed river. During that time, that is not important, my lord. Your lordship kindly come to them. During that, I have, my lord, next page, my lord. Next page, my lord, last 2-3 line, my lord. I went to meet the circle officer, madam, inform everything. I am reading the third paragraph whole, my lord. After practice, I came to my residence. My husband did not return till that. I inquired sister-in-law whether the husband has returned. She replied negative. During that, I again called Suman Biswas to inquire whether he has seen my husband. He replied that he has not seen husband since it was dark and my husband did not return back. I went to the market. During that time, one of my colleague also went to me, was in search of my husband, but we could not find him. Then we went to DL Mittal. He told me the husband school day. During that, I attention Gaumapura Nepali. I call another colleague, my husband. He also disclosed my husband is not resident. I have tried my level to search my husband, but I could not find. As I not receive information, I went to meet circle officer, madam. Inform me. She asked to file an FIR. Accordingly, I went to the PS, informed the matter to the police. Police officer, she told me that they will find my husband. They asked to come to the police station on the next day. Therefore, I called my husband, informed that as well in the morning, they have returned his number. She was informed to the police. That was not mentioned, but seems that on that day also, he informed the police. Next paragraph, not important, my lord. Next, on reaching the place of Pokhara, I see the vehicle nearby the road. The marshal informed of see the key of the vehicle not there. We had brought the additional key of the vehicle. Police took the vehicle dead body and handed over to the police. Police has conducted me postmortem report. Dead body of my husband, Mio. Police called me, record my accordingly. One day I came to PS. Police has arrested me in present case. I am also not involved in the present case. When my husband was murdered, I called my person several times. I am not involved in the present case. The police took me to the confessional statement provided under 160. I have given deposition before the magistrate. The confession deferred by executive magistrate are my signature. When this confessional statement has been exhibited, it was not objected by the defense side that this confessional statement has been taken on coercion and others. Nothing has been. Rather, he admitted this confessional statement. Then cross-examination is declined. Then most importantly, have PW6, my lord. Before going to the PW6, I shall go to the confessional statement of the Suman Biswas, my lord, which your lordship will find, my lord, in page 42 to 46. Have your lordship got it?
Yes.
I read that confessional then accused namely Suman Biswas is brought before me that 29/12/2000 Mayo 16:50 hours at his confessional statement. I have ascertained the LS of his punishable 302. I have asked the accused in detail relating to the detention after arrest. He stated that he was arrested Mayo at about 20 hours. Detained at PS Mayo for about 20 hours. From 20 hours to 16 before brought to the court. He said he was in the police station 20 to 16 hours. That is important, my lord, because it's categorically stated that was not denied by the prosecution. That he was where he was police custody, meaning thereby before 20 hours of the recording the 164 statement. I found two persons, my lord, PW6 along with PW6. Both the person has said that he was produced from the judicial custody. But by lord, my lord, defense has never said that it is not the fact he was not produced from the judicial custody. No suggestion has been made. The accused being asked whether he has got injury, mark, or violence in her body. If the medicine notice on the person, but clear description in the necessary gravity mentioned here. In case of injury notice, the accused inquired how he sustained injury, above injury required. No any injury found. My learned friend has vehemently argued before the court that he was tortured, serious tortured. What he made this point, first time he raised this point in 313 statement. Before that, he had not made any statement that I was tortured. My 164 statement has been recorded. I have authority, my lord. I will come later on, my lord. This point, my lord, is very important, my lord. And when he was medically examined, no any injury was found. To normalize the accused found out to, I inquired the following. What is the age? What is your merit? What is your merit and have got children? What is your occupation, monthly income, private, commercial, whether your monthly income is sufficient to maintain your family? I have explained the accused 154 statement to certain. Do you know I am officer of police, but a magistrate? Answer is yes. Whether any influence is made by the influence confession, there is no answer, my lord, in my copy, my lord. I do not know whether that is available or not. Do you know you are not bound to make a confession? Yes, he know. Do you know that if you confess accusation, it may be used evidence against you? His answer is yes. That is important, my lord, because all this thing has been mentioned in the High Court rules, my lord, and that High Court rules has been followed, and there is an authority, my lord, to that effect. This question should be asked to the accused. Why you want to confess? To reveal the truth. Do you know you should say nothing is untrue, that you should not say anything because others have told you to say it, liberty to say whenever really you desire to show? Yes. Do you know there is no police officer associated with the investigation in the history? You are completely under the supervision of the court. You need not be afraid to the police. He said yes. Whether the police promise or accused you will be made approval? No. Do you know you may be convicted on your own confession? Yes. He knowing everything, by law. Thereafter, he is given the 164 statement. I assure that you will not be remanded to send back to the police even you do not confess. Are you clear about it? Answer is yes. When he was like that, he will be sent to the judicial custody. If he retracted the confession, he refused to give the confession. He said, answer yes. I have placed the supervision of Ram Bahadur ALC for reflection treatment from 1650-63 hours. He is not the police officer, my lord. He is the one of the employee of the court, subject to correction, right? Subject to correction, my lord, which is equal to more than period, which is police custody. Ascertaining the investigation did not have any touch with the accused this period. My lord, judicial executive is functioning as a judicial magistrate in Arunachal. He has said that it is equal or more than equal to the police custody. He conjoined with the paragraph 3, 20 hours before he was in police custody. That will be corroborate to each other, my lord.
What is it?
Meaning thereby, he said before 20 hours before he was in police custody. That was mentioned, paragraph 3. And if we read along with this paragraph, the more than period in police custody, that is corroborated, my lord. The accused is again brought before me 6:30 place. He had been explained 164, particularly those mentioned, and being satisfied he is fit in mind and prepared to make confessional statement voluntarily, which is as follows. Name has been given. Do you want to give any confessional statement voluntarily? Again asked. He said yes. When after reflection time, he brought back to the court, my lord. He said, do you want to give confession? He said yes. Now tell me, what do you want to say? Srimati Nangung Masa, I was in love with each other. This is the motive of the murder, my lord. Everybody, I used to see her. Wherever I used to go out, I would see her, people living. She complained that her husband was a hindrance between them. These 3 points is the motive of the murder, my lord. On 21/12/2016 at 8:30 hours, I was waiting for Let Manthai Masang at the garage. Opposite to old Deputy Namphai was told, Srimati Nunu Masa is dead. He has left Namphai for his duty. It is corroborated with the statement of PW5, my lord. She categorically stated he has inquired about it when he will come. I am linking the circumstances, my lord. That is why. Then I saw the vehicle, Manthai Masas. I stopped vehicle, boarded it. We want to TRCam and meet a lady to get some money. But Manthai told me that he was getting late of his duty, so we returned halfway. On the way, Manthai asked me why I used to go his quarter and meow. I told him that his wife used to ask help for getting household item service, which I was being to do it. Then he asked me whether I have any affair. I told him that we are having an affair, and I cannot live without seeing her. Then Mathai slapped me once my face. Out of anger, I retracted, pulled the driver's seat belt tight around neck and strangulated him till he is dead. Again, I moved to the back seat behind him and cut. The seat belt of Dow in a car tightened belt around his neck to make sure that he is dead. Thereafter, around 30 minutes, I took Dow, stabbed him twice in stomach. and to ensure his death. Then I threw a mobile phone down, broken in a river view, like, and the parking light reflector. I ignited the seat belt, shifted to him, navigator seat, and leaned down the seat behind, so that dead body was not easily. Then I parked car on the roadside properly, left onto one main road. I came to that garage from where I boarded Mathai. I took my car where I parked there when Jagun for money. I had lunch, come to evening. One thing is corroborated with my lord disclosure statement that he threw the mobile phone down, broken inner view mirror. Nancy had broken trying to step me. That is corroborated, my lord. I'm coming later on, my lord, when 27. I argued the disclosure statement. Why did you kill him? Since I was love with Nanchung Maso, wife of disease. That is the motive. Did Simoti Nanon Masang ask you to kill him? No, she did not tell me kill, but she used to complain that because husband were unable to meet her, is her other easily. Did and Srimati Nanong Masang had any direct conversation person over phone before, after my, in the morning about 6:30, she called me while I was bathing. So I could not take the call. Then I called back her 8:30 hours. And she told me her husband has left. Then I again evening 70 called me and called husband. In the before committing the murder, he called the wife of the deceased person. Since a year, did you extramarital Nonung Masai since Hyundai? Yes, in about a year since bought in the car Hyundai. Did you physically listen Nonung Masai? Yes, several times. Mangthang Masai knew about relationship? Yes. We are alone, we are giving companion to the crime. Yes, I was alone. He admitted. Where the crime committed at TR camp, approximately 100-meter main road about TR camp. Did you carry any weapon like Dao, etc.? No. Was the murder pre-planned? No. Is he handy except that? Yes, I know him. I came to throw him. He had illicit relation. Did you give any financial assistance? Yes, I give her 40,000. So and so, so and so. Next page, last part is important. I did the whole. The statement is recorded as early as possible. Accused, whenever question put question, the question should be recorded. The answer is a statement long scape sheet serially numbered. The inside have a statement begin in the form. I am fully conversant with the provision of Rule 23 of High Court Rule, particular and the law regarding the confession. And I have recorded the confessional statement herein below. Principle, legend, and provision of law. I have explained Sumanta Singh that he is now bound to make confession. That is important, my lord. And if he does so, any confession, he may use evidence against him. And I believe that confession has been made voluntary is true. It was taken, my presence hearing was read over, again admitted, be correct, and contemptible. Registered as satisfied. This satisfaction is very much necessary, my lord, as per judgment of the apex court. Satisfaction of the magistrate utmost necessary, my lord, for recording the confessional statement. And his satisfaction is necessary. One thing my learned friend has argued before the court, this is 24 hours, this is 48 hours, this is 76 hours, 4 days, 2 days. Reflection time was not given. It is, I have done today, I have also judgment, my lord. It is not necessary that 24 hours is there. Only thing is that, my lord, whether he is at that time was not influence of the police and not influence of the other, that is important, my. Just like I am arguing, my lord, you look at National Security Act, delaying disposing representation. Sometimes even 7 days delay, Aslam Zahir, representation was not disposed. That is why detention order was it. Sometimes what happened, 1 month delay has been over. If there is reasonable explanation that delay, then my lord, detention order will valid, my lord. Like that, my lord. Satisfaction of the magistrate is necessary. For the recording the 164 statement, that is utmost necessary. And if your lordship go to the cross-exam PW6, my lord, magistrate statement, your lordship kindly look to the page 26, 27. Apollo Jets Longpai. On 29/12/2016, I was serving as ESC cum Judicial Magistrate Phatkar at the office of ADC Meo. On that day, I had recorded confessional statement by Ekus Suman as he was forwarded on requisition by for recording his confessional statement. The Ekus Suman was confessed before me that he was killed. This is late Manthai Masang by strangulating him through seatbelt of the vehicle after strangling the accused stabbed twice by the dog which was inside the vehicle. On 3/3, I recorded confessional statement. Another accused person has confessed that she had an extramarital affair with accused, but she denied that she is not killing Masang. The accused standing in the norm, namely Suman, identified the person he is killing me. Exhibit 4, confession as a deposed by accused Nunang Masang. Exhibit 5, accused Suman Masang signature. Then your lordship kindly go to the cross part. Whether any suggestion has been made that confessional statement was taken by coercion or giving any pressure, nothing has been available here. Whether confessional statement was not by following procedure, that thing has been there in cross-examination. And there is a judgment of the apex court. If that is not available, my lord, meaning thereby this statement of the accused is admissible in evidence and can take by the prosecution, can take by the court to convict the accused person. I have followed the procedure as per 160 while recording the confessional statement. Thereafter, no suggestion has been made. The accused person, namely Suman বিশ্বাস, was produced from the judicial custody Meo. Thereafter, no suggestion has been made. No, it is not the fact. He was produced from the judicial, he was produced from the police custody. That was not available in the statement. In IO also said, while the safeguard has been given, which has been mentioned, was not given, that was not in the cross-examination of the witnesses. That is not available. Meaning thereby that that statement is admissible on the eye of law. Then your lordship kindly come to the, my lord, PW8, my lord. PW8 is the police officer, my lord. Before that, my lord, I am reading the statement of 164 statement of Nanung Masang, PW5, my lord, which your lordship will find 3841. Only 11 times. She also asks all these things. He said, that is the statement, page 39. All the safeguard under High Court Rule 23 has been given, my lord. She said on 21/12/530, Suman বিশ্বাস, Suman, page 13. Have your lordship got it?
Yes.
Yes, my lord. Call in my mobile number. I could not receive the call as I was lying bed. My husband was outside working in the compound. Later on 15 minutes, I woke up and he told me he was leaving for Jagun. So he asked me to come outside that he could. While driving the vehicle passing to the residence, I had refused to first time also present, but I continuously insisted. I reluctantly went to get at the very moment to his car and joined my husband at his work. Then your lordship kindly come to the next page, my lord. That first 41st line, my lord. Suman again called me over phone and inquired whether my husband has left for duty or not. I told him that he has already left few minutes ago. Then my lord, he made statement that my other, and importantly, what was the relation between you and Suman? We had extramarital affair in February 2016. Did you know? Had any physical relation? Yes. Then your lordship kindly go to the, my lord, statement of the IO. PW8. Page, my lord, 30 to 33. On 22/12/2016, I was posted police station Meo sub-inspector. On that day, One written FIR was filed Lincoln Massage alleging that 21/12 around 8 o'clock in the morning, his younger brother Mathai Masang, who was serving as a SSA teacher, did not return back home. The car was found 39. During investigation, I visited, the photograph was taken. There was not print, PO. I had taken photograph, said fingerprint, extra recovery footprint is found in the car and same was collected. It was inquest was collected and CAC after PM visa were collected FSL examination. My Rainer friend has argued before the court that was not produced before the report or other thing, or which has been collected, not sent to the FSL, fatal to the prosecution case. Actually, this is a part of the, I admit, defective investigation. For defective investigation, he was not prejudiced. If he was not prejudiced, my lord, that is not the fatal the prosecution case, my lord. There is a judgment, my lord, of the apex court, my lord. The car deputy recovered CDR of the deceased wife obtained. On honors, it was found that wife of the deceased constant are there. Accordingly, I apprehended the accused Suman Biswas. Accused has admitted he has committed alleged murder. Accordingly, I went to the residence of accused. One disclosure and either I have seized the show. The accused during interrogation that accused has stated while committing, he had thrown the Nokia mobile handset. This is nearby place. He also stated Dow used by staking thrown after commission of the crime. As per the disclosure, I took the accused placer aside and recovered the Nokia mobile handset from the placer. I seized the cloth of the during the commission. I pause here, my lord. One thing is that, my lord, this one was referred in our High Court to the full bench. Suppose sometime disclosure statement also not made, my lord. And how can whether the as per statement of the accused which has been recovered can be taken as a positive evidence on record? That's that reference point has been decided our High Court by the 3 judges bench categorically that if the statement is not available, then also if the IO has said in the statement, then that is admissible in record. Here, my lord, statement is also available. Only that part of the evidence can be taken up, which is used for recovery of the, my lord, incriminating material, my lord. That the full bench reference, our High Court has already been decided. Because he is already attacked the disclosure statement. That is why I am submitting all these things.
Judgment.
Dear so, I have recovered the Nokia mobile handset. This is nearby. I seized the cloth accused who were commission of crime. Later on, the seat belt belonging to the accused seat belt was weapon of death. After obtaining the CDR, the phone belonged to the accused. It was found that they had some illicit relationship. The accused had admitted having illicit. It was found that the accused was hardly relationship wife of the deceased. I am taking only on this part of recovery part. On the basis of the statement made by the accused, the Dow has been recovered, man. That is the positive evidence in the case. As per statement of the morning incident, he called the wife of the deceased, asked whether the deceased Mathai resident. On the way, I was forwarded Suman Biswas before the magistrate for recording the confessional statement. On the confession statement was recorded on Magistrate 164. On completion, I found that 302 has established Exhibit 1 of the FIR, Exhibit 2 handling dead body of signature. Exhibit 3 is the seizure memo. Exhibit 164 statement of Nano Masang. That was not, my lord, objected by the prosecution, my lord. Next, Exhibit 5, the confessional statement of the accused. That was not objected. That was not made under objection. Exhibit 6, postmortem report. Exhibit 7, rough sketch map, PO 7A. Exhibit 8 is the disclosure statement of accused under section 127. 27 Evidence Act. 8A is my signature. That was not objected by him, my lord. When it was exhibited, it was not objected. Exhibit 9 is the seizure memo of the car and my signature. Seizure memo, all these things, my lord, which has been mentioned. Not my lord, objected by the defense side, my lord, when it was produced before the court, my lord. Then, my lord, cross-examination is important, my lord. The accused had confessed before me, magistrate, regarding the commission of murder. There is no eyewitness declaring present. During that recording 164 statement of the accused was in judicial custody. He also said. And the confessional statement of the was recorded magistrate as per my application. There is no suggestion has been made that disclosure statement is, my lord, forced and fabricated. And my lord, other 164 statement is forced and fabricated. It was taken on duress. You have tortured him while he was in police custody. Nothing is available in his cross-examination, my lord. One, my lord, your lordship, kindly go through the disclosure statement now. Page 27. Page, my lord, 47, 48. That is the disclosure statement, my lord. He has, my lord, Mayo PS case number 302 TR Cam in presence of witness Suman Biswas on 21/12 at around 8:30 AM between 8:30 to 11 hours. I committed the murder of Mathang Masang, husband of Siude Masang, inside his AR at TR Cam and TR Cam gate of the car's seatbelt driver also. I use one Singpho Dao to inquire him into the lower abdomen parts of the nervousness. I threw his phone and the Singpho Dao near the jungle of the place of occurrence. Here, my lord categorically stated that he saw the Singpho Dao and other at the jungle of the nearby place of occurrence. It is on the basis of this statement, the seizure was made of Singpho Dao, my lord. That is available, my lord. And one thing he has argued, my lord, that this goods has been recovered in the open place, Singpho Dao. That is not, my lord. He has thrown to the jungle, my lord. If your lordships go to the Arunachal Pradesh, my lord, jungle, my lord, kilometer to kilometer is a jungle, my lord. So how can, my lord, he said this is an open place, my lord. It is not that it was thrown in the lotus field, my lord. Then your lordship, I threw his jungle in the jungle. Then your lordship comes to the seizure list, my lord. Page 54, my lord. Circumstance under which the article is arrested, accused took the undersigned to the place of occurrence, so does the place where he threw the item accordingly seized. One Nokia mobile phone, one Singpho Dao, which scabbard wooden with design length 41 centimeters, so and so, so and so. That Dao has been recovered, my lord, on the basis of disclosure statement made by the accused person before the investigating officer. Secondly, investigating officer categorically stated he has disclosed before me that statement that Dao has been thrown to the jungle. That evidence is available. If we conjoin reading all these things, my lord, this disclosure statement is available and on the basis recovered. And if you conjoin reading with the 164 statement of the accused person, then, my lord, both the things are corroborated each other, my lord. But he is correct, only disclosure we can take, but the discovery part, not other part. Only discovery. We take the discovery part, only take the discovery part. And other part is the 164 statement. Motive has come from the PW5 statement, as well as PW234 also touches some, my lord. Categorically stated motive that there is a love where he is the hindrance, husband is the hindrance, that he committed the murder. That is the thing. And my lord, I go through the, my lord, judgment, because he has already shown all the, my lord, evidence exhibit. I go through the judgment, my lord. As it is clear from the, my lord, argument, because no particular PW6 and 8, my lord, no suggestion had been made, and there is no evidence that the accused was tortured in police custody, my lord. That is not available, my lord. And 164 statement was taken under coercion. This 3 point is important, my lord. And another thing is that both the person has said accused is produced from the judicial custody, my lord. And no suggestion has been made that he was produced from the police custody, my lord. No suggestion that he was produced from police custody. No suggestion. The voluntary statement is not made. I said that accused Suman Biswas told that knife was found in a jungle. That was not, my lord. They have in cross-examination of the witness, they have never said this thing. This voluntary statement was not made by the accused person. And my lord, PW category state about the motive of the murder. Now I am coming one judgment of our court, my lord, Ashwini Kolita, my lord. The citation is 2022 3GLT 252. One thing is that, my lord, before arguing these things, my lord, 2022 3GLT 252. Earlier, when we, my lord, practice in the High Court, my lord, the theory practice, procedural practice is that the judgment which has been shown by the defense side or prosecution side, that citation should be provided to the accused person by the defense side or prosecution side. But nowadays that has been changed. I repeatedly asked him, he has not given that his citation. This is not good, my lord. As per me, my lord, subject to correction, my lord.
Have you given your judgment?
No, he has also.
Yeah, I am given the citation right now.
He has also not given. Yesterday,
No,
he
no.
was reading in the open court. Yesterday, I was also reading in the open court. It is
No,
not that
no.
he has given
He
in
is
advance.
reading
copy.
the part, my lord. What is the citation
Oh,
of the judgment? So that I can.
One should practice before he preaches.
Yes, sir. If you want to teach me,
ना, ना,
no, no, no.
अपने मुख के लिए कोई है।
2022 3GLT 252. Please write down. Ashwini Kolita, my lord. I am relying on the, my lord, Ashwini Kolita judgment, my lord. Paragraph. This is the case, my lord, where, my lord, a murder was took place in a hotel, my lord. Subsequently, body has been, my lord, taken to the, my lord, that overbridge near, my lord, Nehru Stadium. And, my lord, body has been recovered from there. Basically, in this case, the person concerned, accused person were convicted on the basis of 164 statement of the accused confessional statement of the accused person. And what does court say, my lord? I am submitting before your lordship, para 50, my lord. Para 50, page 240. Have your lordship got it?
Yes.
As noticed above, in his statement recorded under 166 CRPC, accused Ashwini had disclosed all other relevant facts, but craftily avoided admitting in specific terms that he had killed deceased. In other words, accused Ashwini Kolita in his statement recorded under 164 CRPC has substantially admitted all the relevant facts, which when viewed in the light of evidence available on the statement of accused Ashwini Kolita contained on the exculpatory statement. Even if it is held that confession of accused Ashwini Kolita contain both exculpatory and inculpatory statement, in view of the division of Appeals Court in Nishikanta Jha and Kesaram Bora, we found the submission of the learned APP that it would be permissible for the court to segregate the exculpatory part from the confession of the act only. Then your lordship, page 55. Some guideline has been given in my lord Robindra Kumar Pal, Dara Singh. Before that, 164 statement has never said, 164 CRPC has never said that you should give this time for the reflection of the accused person. Before that, my lord, I am going 164 CRPC letter, I am reading the judgment. After referring the various decision, earlier decision to the principle be followed, while recording the confessional statement of the Honorable Supreme Court had called out the guiding principle for recording confessional statement of an accused under section 164 CRPC. In this case, Robindra Kumar Pal, Dara Singh, as per 60 produced wherein below reference, the following principle enlarged. The provision of 164 must be complied not only from but in the essence. Before proceeding to record the confessional statement, a searching inquiry must be made from the accused to the custody from which he was produced. A treatment he had been receiving in such case in order to ensure that there is no scope of doubt such extraneous influence proceeding from a source interested in the process. That has been done in the instant case. I have already read, my lord, the earlier part. That whether you are influenced by someone, whether you are coercion, everything has been. A magistrate should ask as to why he want to make confession surely go against interest of the trial. That was also mentioned, my lord. The maker should be granted sufficient time for reflection that as per satisfaction of judicial magistrate that is necessary, my lord. That reflects of the what could be deterred. In this judgment also that is mentioned, my lord, later on. He should be at a protection from any sort of apprehended torture pressure from the police in case he declined to make confession statement. Categorically stated that if you refuse to give confession statement, you will be sent to the police judicial custody. That has been mentioned, my lord. A judicial confession is not voluntarily is unreliable more when such confession is detected. The confession cannot be based on detected judicial confession. What happened, my lord, if someone is tortured, when he was sent to the judicial custody, immediately he should file a petition because judicial custody, when given a accused, he was under the supervision of the court. In police custody also, he can file a petition that what 164 has given I detected because at that time that the torture has been done and under coercion this has been taken. And he has first detected 313 statement that is available in the case at the later stage of the argument. After prosecution witness has been examined, this 313 statement refusal is no value in the eye of law, my lord. I am coming. Because of reflection, the accused should be completely out of police influence. Judicial officer who is entrusted duty recording must apply his judicial mandate, satisfy his conscience that statement accused not on account of extraneous influence on him. It is the satisfaction of that judicial officer, whether he is other influence or not, my lord. The timing is what he has mentioned is a technical thing, my lord. 5 hours, 2 hours, 3 hours, 48 hours, my lord. Confession usually court requires some corroboration from the concept before then. Then your lordship kindly come to the para 65, my lord. Wait a minute, doctor. Page, my lord. Para 65, my lord. What follows from the above mentioned discussion rely upon the learned counsel for the it is ideally minimum 24 hours. Time ideally 24 hours should be granted for the accused for reflection before the recording conference. However, failure to guard at least 24 time for reflection would not per se make statement of the accused recorded under 160 as bad in the eye of law. If time has been less than 24 hours, that is not bad in the eye of law, my lord. It will be depend on the facts and circumstances of a given case whether the sufficient granted to the accused for reflection before recording confession. What would be, however, be utmost significance for the court assess is whether the confession will be recorded in compliance with the procedure laid down in section 164 CRPC or whether the same is voluntary free from inducement appear to from the evidence available. We do not find a reasonable basis to doubt the confession of 3 accused persons noticed herein above are not voluntary and truthful. The next question pattern before our magistrate put the question accused person why they wanted to make confession. In the present, it appeared the evidence on record that people had specifically asked the person as to why they wanted to make confession. However, it is also apparent from the material on record that the accused was sufficiently warned on the consequence, but despite of the same, they were shown their willingness to record their confessional statement. The London magistrate was satisfied that the accused person were voluntarily willing to record their confession. We do not any justifiable ground to doubt the correctness of such satisfaction of the magistrate. After recording their statement, the accused was sent to the judicial custody. Here also, my lord, he was sent to the judicial custody. There is material corroboration of the confession accused from other evidence reliable record, therefore truthfulness of circumstances is well established. Here also, my lord, 164 section and 27 disclosure. it is also fine that all other procedural requirement laid down 164 CRPC has been properly complied with while recording the statement of the accused person. Here in the case has been given and he has not made any suggestion before the court that I was not given the safeguard provided under CRPC, my lord. Even I think 330 statement also he has not said. All this subject to correction, my lord. When I go to the 313 that I read. Moreover, the appellant counsel have not been able to show any prejudice being caused to the accused person due to failure on the part of the PW4 to put question to the accused as to why they wanted to record. One question was not made. That if you made that statement, it is goes against you. In cynical that was not made. That is also not prejudice because this question was not raised by the defense side at the time of trial, my lord. In view of the above, we are of opinion that having regard to facts and circumstances of the case, may failure on the part to put a question to the accused why they wanted to record the statement would not vitiated effect on the impugned judgment. Categorically stated, my lord. Then your lordship kindly look to the my lord, paragraph 68, my lord. Loss is well settled. Conviction can be based even on retracted confession of the accused person, what has been done in the instant case. 313 he retracted at the later stage. If the same is found have been recorded as per prescription law, also found voluntarily, truthfully, there is a corroboration. In Manjit Singh by so and so, while considering the question whether the retracted confession or could be relied on the convict, the accused, the episcopal held the retracted could be used against the accused as well as co-accused provided the statements were truthful, voluntary when made. In this case, the two accused recorded confession statement, the subsequently retracted their statement. In 69 paragraph, in Babulal Udnes Parma, the apex court held a judicial confession has undoubtedly admissible if evidence, it is a relevant fact. A judgment of conviction can be based on a confession if it is found to be truthful, deliberate and voluntary. The voluntary nature of confession depends on the whether there is any threat, inducement, promise is judged on the basis of entire prosecution story. That is not available, my lord. I have already read the statement of PW, my lord, 6, my lord. It was not when she was cross-examined, this question was not put. In Bhagavan Singh, the apex court held that the burden of the proof, the confessional statement obtained by threat, duress, promise was on the accused. He saw the evidence. It was given threat, promise, or duress. This statement was taken. The above law has been retarded the case and K.I. Pabunmi. In Rajan Boru's statement, this court has observed that it is not the requirement law that once a confession is detected, the court will presume the confession was tainted. It was further observed that non-retracted confession was a rarity in a criminal case. To retract from confession was right, accused whom confession were produced by the prosecution in exercise, but it would be injustice. Jettison to judicial confession on mayor premise that the maker of retracted, the court is duty to evaluate concerning the confession looking into all aspects. In case of Dandarsar Burman, state of Assam, the confessional statement accused was recorded before magistrate. During recording the statement under 313, the accused admitted that his confession was recorded by magistrate. He has taken the stand. The same was under the influence of police. He never denied that 164 statement was not taken. He is influence police. However, observing that the confession accused was supported by oral evidence, witness available record, and noticing that there is no evidence on the police torture. The division bench has rejected the plea of the accused, held that confession statement of accused was true and reliable. In the present case, there is nothing on the record substantiate that confession made by the accused was under threat, undue influence from the police. The accused person have also failed to establish such plea leading evidence. We are therefore opinion that retraction of confession by the accused person was not bona fide. Hence, the plea learned counsel does not merit of the acceptance of this case. Meaning thereby, my lord, he have to meet, my lord, that this confession in the cross-examination of the before that When he was sent to the, my lord, judicial custody, he made an application before the police, before the landed court, my lord, below, and said that this statement which has been taken on coercion or mal threat, nothing has been available. There is in the cross-examination part also not available. Only 330 he said this confessional statement has been taken by treating me by the police, my lord. Only 313. That answer has been given by this case, my lord. Then your lordship kindly go to the, my lord. This is the another case, my lord. Devi Singh, my lord. 2010. 2005, 10 SSC 453. Para 5.
No. 2005, 10 SCC.
Nishana. May I read, my lord? Para 5. The counsel for the appellants strenuously contended before us that confessional statement relied upon by the prosecution was recorded by the magistrate without following legal formality, and confession was not made voluntary in nature. Therefore, the session judge as High Court should not have placed reliance on that. It is also contended that the appellant was not given sufficient time for reflection, and magistrate said to have recorded the confession, it is resulted serious prejudice to the appellant. It was also pointed out by the appellant counsel that accused in his statement before categorically stated that he was beaten up by police for 3 days and clearly indicated that confession was recorded under threat or coercion. This was not stated in my case also, my lord. Despite of that, what order has been passed by the court, I am going. The copy of the confession was put before us. We have gone through it. The recorded confession shows the magistrate followed the legal formalities in recording the confession, which has been done in the instant case. The magistrate told the appellant that he was not bound to give any confession if given would use against him. The magistrate also told him that whether anybody had used any force, pressure, procedure, coercion, make confessional statement, which all question has been asked in my case also, my lord. The appellant answered in the negative. He said no. To various answers given by the appellant to query made by clearly shows the confession was voluntary in nature. It is true the appellant had made statement that he was beaten up by the police 3 days. It was recorded by the state that the appellant has showed his back and finger, but there were no injury mark either found on the figures. He, even it is assuming but not admitting, he said, he had this statement, it was taken on question, I was tortured, anything, but magistrate did not found any injury, my lord. Here in the instant case also, my lord. So the statement made by the appellant could not be true. Magistrate had not believed the statement is true. Magistrate would have taken step to where the confession would be under physical threat or coercion. The appellant was produced in court about 12 o'clock. He put the preliminary question, recorded answer appellant. Thereafter, further confession was recorded at about 2 o'clock. So she kindly come to the timing. 2 o'clock. 12 o'clock or 2 o'clock. The appellant had a time for reflection. The appellant was during the time of period in judicial custody. Here also in the instant case also. It is also pertinent to note that appellant had given detailed recording as to how the incident happened. It is stated that co-accused came to him in the evening, offered rupee 1,000 gold chain in consideration do away the Khera bordered sari and Sapti. On the day proceed to Magri behind, so the facts has been disclosed. Thereafter, he lifted the dead body. This also shows the fact that confessions are fully corroborated by the medical evidence adduced by this case. If you go to the 164 statement and 27 disclosure statement, even the statement of the IO, my lord, that disclosure process is fully corroborated with the 164 statement made by this accused person, my lord. He may say minor discrepancy may be there, man. He said right side of the seat, left hand of the seat. That is minor. That is not helping, my lord. But it is corroborated. It is also noticed that a recovery has been effected in the instant case. Doria, Tarban allegedly warned by the appellant at the time incident were blasted. They were recovered from the house of the, there is satisfactory evidence there. So appeal was dismissed and my lord, he is directed to surrender before the court. Next case, my lord, before your lord, is Sankaria. 78 SSC 435. I think he also shown the Sankaria's husband, my lord. I am coming, my lord, paragraph 47, 48, 49. 54. Page 450. For the reason we negative at third point. Para 47, 48, 49. 47 to 54 paragraph. Page 450. Page 450. 47 to 54.
Yes.
For the above reason, we negate third point canvassed by Mr. Gambhir as regard point 4. The magistrate has stated that after recording confession, he had handed over custody of the accused to the so and so, so and so. The Salani card was not under the control of investigating agency. Here also, he was handed over to the one person of the office matter that has been mentioned, my lord. During the preliminary question, appellant magistrate had assured that no case, whether is made confession or not, he sent back to the he would be sent to the back to the police custody. Here also said, if you are refused to give the confession, you will be sent to the police judicial custody. Accordingly, the magistrate, according to his statement, he did not send the accused back to the police custody. Instead, he gives custody appellant Salangar, which meant jail or judicial custody. A suggestion of good care cross-examination after consideration recorded the accused was taken and the witness stoutly refuted his suggestion that his custody was after confession given to him. He, however, affirmed that accused was sent back to the lockup. There is no good reason to disbelieve evidence of the superintendent of police to the FIR after recording confession. Custody was handed over to the investigating police. Mr. Gambhir, so and so kindly correct. Another circumstance we reinforce conclusion that confidentiality was not detected earlier opportunity. That is important, man. Paragraph 51. Another circumstance reinforced the conclusion about the it was not detected the earliest opportunity. The confession was recorded on June 14, 1974. The trial was commenced on January 10, 1975. When the charges were framed, it and explained appellant session judge. At the trial, he was defended by the already observed, was experienced lawyer. The trial dragged on the several months because witnesses were explained piecemeal different. The prosecution evidence was closed on June 14. Accused was examined 313. It was during the such exam appearance was the first time he retracted the confession, took the plea here under duress of the police. In my case, my lord, one thing is important, my lord. He has recorded his 313 statement on my lord. 34 to 37, no? His 164 statement was recorded, my lord. 313 statement on 3/3/2017. No, sorry, man. This is 164 statement. 313 to put there. 34 to 37. Okay. It was recorded on my lord.
164.
No, my lord, 313 statement.
As usual, undated.
Huh?
Undated, page 37, left hand side, blank.
It is not available. Perhaps it is on the record, my lord, when 313 recorded. Before the judgment, when judgment was delivered.
Eighteen 11/2008.
313, 18/11, 2019, my lord.
19.
At page 73 of the judgment. Last part. Examiner goes under 313 CRPC 18/11/2019. And my lord, he has given 164 statement long back, my lord. He has given 164 statement on 29. (29/12/2016), my lord. And 19, almost 2 years, my lord, more than 2 years. He has never acted, only 330 statement, yes, my lord, refused, retracted the confession. Next paragraph, my lord, 313 CRPC, it is during as appellant the first time retracted the, took up the plea here made under duress and police. After bestowing our best consideration all the questions bearing on the point, we are opinion that in circumstances of the case, High Court was in coming to the conclusion that this confession has been made voluntarily, made by Shankar Eko. The next question is confession is true. In this, that question, a perusal record shows that there is nothing improbable, unbelievable. That is the judgment, madam. That paragraph 57 of the judgment, my lord. From facts 1 to 6, confession find corroboration firstly from reliable circumstances evident but in the record. A memorandum, Bhagavan Singh soon after the scene of the crime in the morning, September 9. In the memorandum, he noted that physical facts observed by him, which was according to the light. The explanatory memorandum is next a rough site plan. The veracity of the site put Bhagavan cross-section to silence the genuineness of the document, nor any suggestion put him that this document prepared subsequently or fact noted therein were wrong. Paragraph 57. No suggestion has been made in the instant case also. Then, my lord, para 88, my lord, of that judgment, my lord, page 458. All the science identification of footprint, footmark is developed science. The track evidence not deemed sufficient to carry conviction criminal. At 11 circumstances taken out, the other evidence may reinforce conclude identity of the culprit. In the instant, other sufficient to fix the appellant with the crime. The evidence similarly footmark taken in conjunction with the circumstances. Occurrence, there is a bare footprint which says appear person lent to other appellant as confessional statement which they get going to about the state. To sum up, conveniently established that confession was voluntarily made, it is true, but it received the assurance several material, particular reliable evidence, mainly a circumstances. The confession exhibited coupled with the other evidence record, he unerringly brought home to search the appellant. The crime was committed in most brutal and dastardly fashion. These victims were taken unaware when they were asleep. 2 of them were blind persons. This is the conduct, so and so, so and so. That is why he was given extreme penalty. Then your lordship kindly look to the, my lord. 1994 to SSC, my lord, 467. 94 to SSC 467. Lordship kindly come to the para 22-23. Para 22-23. 478. Yes. Have you also got it? 22-23, paragraph 478. Page 47. Sorry.
Yes.
The High Court rely upon the confessional statement recorded under 164 CRPC, found that same was voluntary, had been made by the appellant without any threat or fear. It contained full confession of the crime, also disclosed in the manner which crime has been committed. The High Court also rely upon the report of serologist V.N. Mathur, who has stated in a chemical report that seized article including blast and so produced by the appellant, the clothes appellant, which tainted blood group, which clothes the High Court stated sufficient corroboration retracted confessional statement. We too further relying upon the testimony sister-in-law material corroboration from other 302. We have considered the retracted confessional statement carefully, analysis the statement. The learned judicial Tarasan Sony, we have referred the confessional statement some detail. In the earlier part of the judgment, we are satisfied that learned magistrate had taken all necessary precautions to ensure that appellant has sufficient time he made his confessional statement. Under no fair threat argument before appearing the court to make his the various questions by learned magistrate the appellant indicate that he had taken all reasonable precautions removed the any trace from the appellant he made confessional. The questions in this under 164 CRPC are probably administrative team. He was told in no certain time he was not bound to make statement. If he that he can be used against him. Learned counsel for the appellant are unable to point out circumstances from which it was inferred the confessional statement is not voluntary one. Let him show, my lord, why it was not voluntary one, my lord. He has mentioning about the technical thing. One part has got here said tortured, that is not available on the record. And I have already read one judgment, my lord. It is duty of the accused to show that this confessional statement was not made voluntarily. It was under threat duress. No information, whatever I pointed out, in which statement was belonging to the appellant, as well as the clothes which stand with the blood that nothing has been pointed out, the doubt or ownership recovery of blasted stored and appellant done Durga Sharma during the investigation. Then you will see come one judgment of the Arunachal Pradesh, Ahung Wangsa Mylom. Criminal appeal number 97 2022 21. Ahung Wangsa Mylom. Paragraph my lord 13. First. Respond paragraph 13, my lord, page 9, my lord.
Yes.
Responding to the above, Mr. So-and-so, learned public prosecutor of state of Odisha argued that sufficient evidence has been brought to the record to establish such framework at both the appeal accused. Mr. Chaudhary submit that confessional statement of accused Ahung Wangsa recorded due compliance with the prescription of section 164 CRPT. According to Mr. Chaudhary, accused person were given 2 days time for reflection of the statement. The fact that learned magistrate explained accused person the consequence of the confessional statement established the fact being if the appellant refused to record the statement where the appellant Ahung Wangsa chosen to go ahead with the same, the aforesaid fact viewed Mr. Evidence by Magistrate CW1 according to Mr. Chaudhary would no room of doubt the statement of accused Ahung Wangsa was recorded by learned magistrate after following the due procedure laid down by the law. 164 statement, what procedure has been mentioned, my lord? And 163, my lord, as well as contending that one confession is found to be recorded in compliance with the statutory provision of law. Same appear to be voluntarily to full the statement accused can be has likely rely upon the learned court in support of the argument of Mr. Chaudhary rely upon the Supreme Court judgment 2025 SSC contending that defense side did not raise any objection as regards to the admissibility of exhibit 9 and 10 when those were induced by the witnesses. Same has been done in the instant case. Mr. Chaudhary has also argued that in absence of any objection raised by the defense counsel, appellant cannot now assail the validity of exhibit 9 and 10 statement. Appellant said Ahung Wangsa respectively, learned 164 CRPC. To sum up the argument, so and so, victim.
My lord, I'm not interfering, my lord. I'm not interfering what he's submitting. Just, my lord, the paragraph which he has read, my lord, just so that in order to avoid repetition, your lordship will just kindly mark 2 days reflection.
But
I'm
I'm
not interfering, my lord. I'm just indicating, I'm not interfering. I'm not making any counter argument.
I never said 2 days, 3 days is not important. This is I argued the case before the court. He want to show that this is 2 days. I also showed there 2 hours judgment is also available. The time period is not important. Although I could not, my lord, show the defense lawyer, my lord, that time is not important. Important is the satisfaction of the magistrate. And another important is that he shall show there is no suggestion has been made from the other side, defense side, that it was taken on coercion and other things. Time of reflection was not given. That is important. That I argued before that. He found two days what he said this thing, my lord. I am not arguing on that. 2 days, 20 days, 4 days, everything else, 2 hours, everything is satisfaction of magistrate is necessary. And he showed that magistrate satisfaction is bad because my lord his satisfaction is stated before the my lord in cross-examination of the magistrate that it was taken on coercion. He had not said all these things. That was not the only 313 he has retracted all these things. My submission is that. I'm giving his answer also, my lord. Your lordship kindly come to the para 47.
Yes.
Forty-six, my lord. In so far advanced, paragraph 46, my lord. In so far argument advanced by the appellant counsel that there is no indication in the confessional statement. Before that, I am going to 45 also, my lord. From the confession, we find that we are produced from judicial custody, also sent back to judicial custody. According to the confessional statement, there is no police personnel present when the reflection time was given by the learned magistrate. The accused also asked why he wanted to confess, and he replied that he wanted to tell the truth. The accused was also aware that he was not bound to confess. Same in like my case, my lord. In so far argument advanced by the appellant counsel that there is no indication of confessional state, the accused was informed that he was sent to the police custody even if he refused to confess. To that exists suffer infirmity regarding the inadmissibility of law. We are unable to agree with such submission. The learned counsel for the appellant fact that the accused was evidently produced judicial custody. He was sent back to the judicial after recording his conduct. It has come to the evidence or record that there are no police personnel present in the office of the learned judicial magistrate, but there is no application of sending the accused police custody. Under this, the mere fact the learned magistrate has not made endorsement exhibited to the effect the accused was informed that he would not be sent to the police custody even he refused the confess. In our opinion, would not have any material facts circumstance. The learned magistrate appellant has not been so any prejudice being caused to the accused person. In my case, it's just stated that he will be sent. I want to say something different, my lord. He has to show how he was prejudiced. He never said in his either manner cross-examination of the witness and 330 statement also. I am going to the 330 statement also, but this thing was not given safeguard. That is why I was prejudiced. He was not said all these things, my lord. It is argument made before the Honorable High Court here, my lord, by him, my lord. In case Dhananjay Reddy, the Honorable Supreme Court has observed the recording confessional under 160 was a very solemn magistrate is obliged to perform and due care ensure that the 160 were duly satisfied. A magistrate should not address in Dhananjay Reddy is held that it would be necessary in every case put question prescribed by the High Court circular, which is intended to put under subsection 3. 164 CRPC. No element of casualness should be allowed to creep in. The magistrate should be fully satisfied the confessional of the accused was in fact substance voluntary. It is the satisfaction of the magistrate that confessional was made is voluntary. A similar view has been expressed in the Barubari Udensin Parma, wherein it has been held that provision of 164 are meant to provide safeguard for an accused and therefore such provisions were required strictly complied with. Paragraph 49, madam. Paragraph 48, the learned counsel could apply argue that it is a case retracted confession. However, from a minor reading statement, we find he did not deny that his confession and magistrate merely for an mere fact, in our view. Retraction of confession, moreover, exhibiting confession statement accused also admitted evidence without any objection from the defense counsel. When exhibited, there is no objection from the defense counsel. That line is important. From a careful reading of the confessional statement, Ahung Wangsa proved that Exhibit 10 as well as testimony of CW and Judicial Magistrate of first class who has recorded the same, we are viewed that the learned magistrate had not only complied with the requirement of 164(3) CRPC. That was followed in the instant case also. Before recording the confessional statement of the accused person, but she had also recorded the same after providing sufficient reflection time accused and may be justified in the fact and circumstances of the case, also reaching proper satisfaction about the fact the accused was willing to make confession voluntarily. More in her deposition, CW1 reproduced in her own voice the nature of confession made by Ahung. The evidence of CW1 remained unassailed or first. Therefore, the fighter has voluntarily truthful the confession of accused Ahung Wangsa, who he read in the light of other evidence record, both shows that his confessional statement was truthful, therefore rightly relied upon by the learned trial court. Thereafter, my lordship come to the page 57, my lord. That is not important, important also, my lord. Section 30, my lord, of the evidence, the confessional statement of the court can be accepted by the court for the other accused person. Section 30(20), you also know all these things that has been discussed here also, my lord. And my lord, para 57, my lord, 57 onward that has been mentioned. Then you will also come to 60 of that judgment. Page 37. Law is settled that in case of criminal conspiracy, direct evidence is very much difficult to find. Conspiracy always has a secrecy, save and accept confession of a co-accused. It may not be possible to find of evidence criminal under such circumstances. Confession statement of co-accused can be brushed aside if the same is prosecution story established by other evidence on record. I take this because PW have said about the motive of the murder of that particular person. We have already held that confessional statement of Ahung Wangsa was recorded after complying the procedure laid down 160 in our view to fullness. Ahung Wangsa is not denied, recorded the so I do not know the same. The above response of the real confessional statement is relied upon by the court. Then, my lord, in case of Superintendent of Police Nolini, the owner who laid down that is the and your lordship, one judgment of Uris Division Bench of Orissa High Court, my lord.
Orissa.
Lordship. Yeah. Huh? 1975 SSC online, my lord, 414, my lord. Para 40, my lord.
Orissa. The other one.
The next piece of evidence in judicial confession made by the accused person before the magistrate, the accused person has confessed to have killed the deceased, but they say that deceased started to abusing them in absence language. The explanation or justice for the assault being somewhat explanatory in nature, the reasonable in connection with the extrajudicial confession being unacceptable to can be discarded, and the inculpatory part of the judicial confession can be relied on in absence of any other infirmity the same. The confession, however, was admissible inadmissible evidence by the session court on the ground that sufficient time had not been given to the accused. The same ground attack is also repeated by the defense counsel here. It appeared from the magistrate that accused body from police disclosed that 12:30 p.m. and he disclosed the identity, and 4 p.m. again 4 p.m. he repeated warning. Therefore, 3.5 hours are allowed. The time it has been mentioned, my lord. Next page, my lord. Paragraph above, my lord. last one, 4 line, no suggestion has been made.
Which para?
That 14 mile, I'm reading my lord book. The object of giving time cool reflection to the accused person is given sufficient time free themselves from possible inducement coercion which might has been exercised by on behalf of the police for the purpose of compensation. Have you also got it? No suggestion has been made either to the magistrate or by the IO. The accused person were terrorized, induced by, or on behalf of the police to make confession, which they did before the magistrate. Which I have already mentioned, my lord. No suggestion has been made. Is that the higher present cases are therefore not parallel to those cases Swan Singh Punjab. In my opinion, judicial confession was voluntarily, as indicated evidence according to me. The learned sessions are wrong, discarding the evidence on the sole ground that sufficient time for reflection has not been given. The confession is therefore accepted a valid piece of evidence. Confession can be based, but in the case of circumstantial evidence, this time will corroborate the judicial confession. Next, para 16. Another piece of conduct is that accused is that they gave discovery of place of burial of the deceased. PW4, the IO has stated all the accused person pointed the place of burial. There is no cross-examination on this point. That is important. That shows that all the accused persons had prior knowledge in the place of dead body was buried. The inference coupled with the conduct of the pointed place of burial is undoubtedly incriminating. Then, in view of the overall couple extrajudicial confessions, there is various specific conduct of this. The only immediate conclusion is that there were any method of common intention of not only causing death of the assault but also causing appearance of the murder in furtherance of the such offense 30 to 34. Then my lord, my learned friend will say about there is some defect in the investigation, my lord. So, my lord, this defect he is entitled for the, my lord, acquittal from the case. I am relying on the, my lord, 2022 8 assessment condition. Oh, 2022 8. Oh, 668. Disha. Six, 8 money. Sorry, sir. In the name of the Mokostos. Paragraph my love 45. Page 691, my love.
Yes.
The detailed extracted provision under section 53A.
45.
45, my lord. Page 691. I am reading from the book, my lord. Paragraph is important. Paragraph 45.
This is online.
Yes, my lord. I am reading from the paragraph 45. The above extracted provision under section 53A. On CRP would go to show that it provided detailed examination which term 53 on personal accused of rape of attempt committed by registered medical practitioner hospital government by local authority in absence of practitioner. Radius 16 kilometers legal provision undisputed factual non-conduct of DNA profile sample of the appeal and contentions 53A. In the said circumstance, of further content, there is an absence of conclusion to connect the sample taken by body of the deceased. Certainly, non-conduct of DNA profiling provision security flow in the investigation. It is a flaw in the investigation, my lord. But then the question emerges of the aforesaid indisputable position is not holding their profiling or whether conviction of the appellant on the said is liable to be set aside and on the sole score. There can be no doubt with respect to the provision that a fair investigation necessary of fair trial. Hence, it is duty of the investigating agency to protect the right of both the accused and victim by adhering to the prescribed procedure in the manner investigation they were ensured to fair, competent, effective investigation. Even while holding so, we cannot be obvious. It is well high settled position solely on account of defect or shortcoming investigation. Accused is not entitled to get acquitted. In other words, it also can be sole reason for interfere of the judgment of the conviction is confidence enough to sustain the same. Meaning thereby that he has said this was not produced, that wearing apparel report was no other report was not. Only on that sole ground, his conviction cannot be set aside. In the decision of Mim Mohammed Omar case held that in our precision, it is almost impossible to come across a single case wherein the investigation was conducted completely flawless, absolutely foolproof. The function of criminal court should not be wasted in picking out the lapses of investigation and expressing unsavory criticism against the investigating officer. If the offences are acquitted only on the account of flaw or defect of investigation, the cause of criminal justice become the victim. Effort should be made to see criminal justice salvaged despite the defect in the investigation. And another judgment is there, my lord. That is, my lord, 2017-11 SSC 195.
2017.
This sir? Listen. 2017-11 SSC 195. There are 30, 43, 44. There are 30, my lord. In C. Munipan, this court extend the law on this point on the following manner. There may be highly defective investigation of the case. However, it is to be examined whether there is any lapses on the IO, where such lapses and benefit should be given to the accused person. The law is well settled that the defect of investigation by itself cannot be ground for the prima facie is given design, negligent investigation, omission, lapses by the perfunctory invest the faith and confident people criminal justice should be endured. Where there has been negligence on the part of investigation agency, omission, etc., which is defective in it, there is a legal obligation on the part of the court to examine prosecution, rehearse the lapses carefully, find that whether evidence is reliable or not to the externally reliable lapses object finding of the truth. Therefore, investigation is not solitary area, judicial scrutiny criminal. The conclusion trial cannot be allowed to depend solely on the probability of investigation. Then 43, 44. The learned counsel appearing for the respondent has been tried to create a then to the prosecution story pointing out inconsistent with the ocular evidence with the medical evidence. However, we are not persuaded with the submission since both the court below categorically ruled that medical evidence was consistent with the ocular evidence. We can safely say that extent corroborated the direct evidence offered by eyewitness. We hold that there is no material discrepancy in the medical ocular evidence. There is no reason to hinder judgment of the court below. In the evidence consistent, this court evidently view of medical evidence on the corroborative, not therefore conflict between the oral and medical evidence. In the present, we do not find major contradiction either in the evidence, paragraph 44, my lord, witnesses or any conflict medical ocular in the circumstance, the minor improvement, embellishment on the part of the human faculties are insignificant, ought to be ignored, since the evident witnesses are overwhelmingly corroborated each other in material particular. Next, paragraph 46, it has contended that the learned counsel respondent has no immediate motive with the respondent commit murder. This, however, the trial found that there is a sufficient motive with the accused commit the murder since the disease defected, and thus putting the 28-30, the long march feeling hatred, enmity between the family. We are not required to express opinion in the light evident adduced direct witness incident. It is settled position that even if the absence of motives is accepted, is consequent the insignificant when the evidence. Therefore, it is a case of direct trustworthy evidence of the witness of commission offense. Therefore, it is a genesis of the motive of the occurrence, not proof of a collective occurrence, not discarded on the ground of motive. The next line of the contention taken line of consideration that the recovery of evidence was false and fabricated. We felt no need to address the event already validly discarded by the trial court or convicted in any case established position law that mere non-recovery of weapon not falsity in the prosecution case where the ample unimpressible ocular evidence is available. Non-recovery of weapon, non-recovery of so and so thing, not producing that thing is not fatal the prosecution case. That has been mentioned in this case. Then paragraph 54, my lord. Finally, it has been paragraph 54. Finally, it has been submitted by the Lionel case from the prosecution story smack of fabrication. It was possible witness discretion accuracy, dragging the body decreased respondent by state ground. We found no force of submission. We therefore appeal the set aside. High Court having evidence will express the court the multiple one on the other trial court has correctly analyzed the material on the record factual. The judgment or order of sentence by the is restored. One important thing of the Milo leading to the discovery of facts, Milo. That is my 2009 2 GLT. Wait one. 2 GLT Milo 414. Move on there, move on there. Era 29, my lord. My first thing is that, my lord, it was sent on reference to the, my lord, full court, my lord, of this honorable court, my lord, to decide, my lord, if whether that statement, section 12, disclosure statement is not available in the instant case, but the statement of the IO is available. IO has stated that this was recovered from so and so, so and so. Whether that can be taken as an evidence on record, because my learned friend has attacked that voluntary statement, my lord. What about the law, my lord? That has to be looked into the matter, my lord. And reference has been made to that point, my lord. Your lordship, kindly come to the era 29. It is quite possible that in a given case, no written record or disclosure statement has been produced, but investigating officer deposition in the court that accusation made statement which led to the discovery is found believable or is not even disputed. Here in the instant case also not disputed by them when this statement was made before the court. Would it possible to discuss such statement of investigating officer only on the ground that he had not reduced into writing to the said disclosure assessment? Such an approach to piece of evidence is not possible to be accepted or correct, particularly when the statute has in the language used therein given no such mandatory indication. No mandatory indication, disclosure statement should be written form. Here in the written form, he may attack the disclosure statement, but he cannot say that this statement was not recorded because he has not denied at any point of time. And this evidence is available by law. Only disclosure part we can take by law. That is, I also accepted that only disclosure part, which has been corroborated with 164 statement I have already submitted. It is worth noticing that disclosure statement has to be recorded. If it was recorded by police officer before the fact is discovered, accused lead to the discovery of the fact. It meaningless to record disclosure after the disclosure statement has already been acted upon. Here in the instance case, my lord, disclosure statement was recorded first. Thereafter, my lord, it was my lord, recovered, my lord. Addressing the initial question as to whether the must lead to the police discover material object, section Apex Code has relied on receiving need to be police officer to take or not the take. Accused has given information. In a given case, it does in bearing admissibility the 11 and so and so and so. Some judgment has been discussed, my lord. Paragraph 34, 32, 33, 34, my lord. From lordship, my lord, that is available, my lord. Now come to the paragraph 38, my lord. Though it is to exact statement of accused, paragraph 38, my lord. But that judgment is important, my lord. 32, 33, 34, my lord. Though it is true that exact statement of the accused which is sought to be proved under section 27 must be disclosed before the court, that such statement should be reduced in writing in order to the court believe that such statement indeed made accused also enable to know that what are exactly stand. Mere fact that written record was not produced cannot be held to be made section 20 inapplicable. With respect, we are viewed that Pandava Roy, if section 20 would not apply to all cases where disclosure statement is not proved to be reduced in writing, is not correct law. Whether the court is given case should not believe that disclosure statement which has not been reduced in writing in a question oral evidence regard the statement discovery of fact. Then your lordship come to the paragraph 43. We express paragraph 43. We express our agreement with the exposition of law. Tilak Gogoi has been discussed in paragraph 42, my lord. 42 is important, my lord. Because it is a long judgment has been mentioned, I am not reading, my lord. 43, my lord. We express our complete agreement with the Tilak Gogoi. It is necessary to emphasize that though written record of a statement made by the accused leading to discovery of fact is not necessary, in order to make statement admissible in evidence, what is necessary must be borne in mind is that there must be an evidence or record to show that before discovery of fact place, a statement was made by the accused, though such statement may not be reduced into writing. If the accused merely into a police officer help in the recovery of incriminating piece of evidence where the stolen article is found, section 27 will not be attracted if no evidence fact accused had made any statement which led. The pointing out the place where stolen article was found, it is relevant to section 8 of the Evidence Act, conduct of the accused. The paragraph 48. In it be, however, pointed out that discovery must be subsequent to the making disclosure statement. Where disclosure is made by subsequent fact, it is disclosure statement whether it account or be relevant only when the confession or not proceeded the discovery of fact. 54, my lord, in Buddharas, this court, paragraph 54, deal subject observe that the statement which is admissible under section 27 is one which is information leading to discovery. Thus, what is information being informed is the same be proved, not opinion formed on it by the police or in other words, exact information, while custody which led to the discovery of article has to be proved. It is therefore necessary for the benefit of the both accused and the prosecution, information even should be recorded proof. If not recorded, the exact information should be adduced evidence. The basic idea 27 of evidence doctrine of confirms subsequent event. The doctrine is founded the principle law. If the fact is made stand, guaranteed the information might be confessional. From the emphasis portion of the observation about Buduras, it became clear that information shows the accused gave the information which lead to the which prosecution rely upon, shows the accused gave the information which led to discovery should be recorded proof. It is not so recorded information. Evidence, obviously, such evidence mean evidence. Nonetheless, there is transparent forbidden Buduras is that when the statement is leading to discovery has not been reduced in writing, such statement is still admissible in evidence, though probative value therefore would be dependent upon the facts of a given case. Because we have discussed the point that we conclude that disclosure statement be admissible, 27 is not statutorily required to be reduced in writing. So PDS demands such an information exactly allegedly to have information given by admissible. This difference has been stamped, answered accordingly. I argued this point because my lord, he has attacked that disclosure statement. Also, he has not denied this disclosure statement. And he has not stated anywhere that this disclosure statement was subsequently prepared after the recovery of the goods. That is not his case, my lord, in the instant case, my lord. So, my lord, even it is his defense said that disclosure statement is some defect also, then also IO statement, IO has categorically stated, he stated like this has been recovered. That is also admissible in evidence. But my humble submission, not admitting the fact, this discovery statement, disclosure statement is a valid statement following all the procedure of law, because he has never denied this disclosure statement. He has said that this is fabricated document. This was statement, what has been stated in the content of the statement, that is not correct. That solution is not available to the IO. If you will also go to the IO statement, then we do us to this. Then your logic look to the 2002-8 SSC 45 para 18. Yes. Page 58, my lord. 11 page, para 18. Have you also got it?
Yes.
Emphasis on late circumstances on recovery of weapon assault on the basis of information used while in custody. The question and evidence related recovery of sufficient person to the guilt to the accused. Section 27 of the Act is by way of proviso to section 25-26 and a statement by way of confession made in police custody which distinctly relate to the discovered is admissible in evidence against the accused. The position of sanctity would deal with the Delhi administration versus Balakrishnan Moyo and Muhammad Inayatullah versus State of Maharashtra. This was so much information, so related to distinctly that they discovered are very important whole force of section concern of them. Clearly to the extent of information admissible must depend on the exact nature of facts discovered to which such information required to relate. The ban as imposed by the proceeding section was presumably inspired by the fear of litigation that a person under police influence might be induced confess pressure. If all that required ban on the inclusion confession information relating to the object, it seems that reasonable suppose that persuasive power police will prove equal the occasion. The object of provision of section 27 was to provide for admission of evidence, but for existence of the section could not consequence the preceding section he admitted evidence. It would be appear that stand in order to render evidence leading to any factual admissible. The information must come from the accused custody to the police. The requirement of police custody product extremely anomalous result and may lead to the mass available existent cases where a person who is subsequently taken into custody become accused after committing a crime. Police officer voluntarily goes to him to the police station state circumstances, material fact in consequence information received. The information under section, if the information did not come, a person, custody police officer did come, custody the statement which is admissible under the section is one of the leading to discovery. Thus, the admissible being in information, the same has not proved, not opinion formed by the police officer. In other, the exact information given while in custody is led to the disprove. It is therefore necessary for the benefit of both accused, the prosecution, the information should be recorded. If not so recorded, the exact information must be adduced evident. The basic idea of section 27 is doctrine of confirmation of subsequent event. The doctrine is the founded principle if any fact discovered must stand of the obtained prisoner and discovery is true. The information might be confessional, non-inculpatory in nature, but it is result of discovery, but it becomes reliable information. It is well settled. Recovery object is not discovery of fact. Decision of Privy Council in Pulukhuri, Kuttaya and Emperor is the most quoted authority for supporting the interpretation of facts discovered is section embraces the fact. No doubt the information permitted to be admitted evidence concerned person distinctly relate fact discovered, but the information get admissibly needs so truncated or to make intensive, incompressible, the extent information admitted should be consistent. Mere statement that accused led to the police witness to where he connected his article is not indicative information given. Accordingly, my lord, in this case, my lord, that has been, that has been accepted by our High Court in Rajiv Phukan case. This position. We are not on that. We are only discovery part. That's so and so weapon has been thrown to the jungle on the basis of information that has been recovered. That part only. Other we take from the 164 statement of the accused persons. Then one important judgment is there, my lord. That judgment, my lord, defense, if the defense raised not any objection, then what will be the effect? My lord, 2025 SSC 782. That also did the voluntary or confession effect of retraction. That is also. Para 20. Para, my lord, 23, my lord. Lordship, I read from 22 also. 23, my 22 is. Magistrate has said, my lord, he failed to comply one provision, my lord, that if he is detected the confession, he will not send to the police case. That was not mentioned. Paragraph 23. In the light of vehement attempt of assailing confessional statement of non-voluntary, right guaranteed under Article 20, subsection 3 of the Constitution in the alternative reliance of being detected by the Article 20, subsection 3 said, no person can be compelled to give evidence against him. Man. That was, it is on. It will be briefly noticed that on a conjoint reading of confessional state comprising 163, 164. 163 important, my lord, whether any force has been used, that is important. That is why this High Court rules, this prescribed provision has been given, whether you have been threatened, whether you are threatened, if you are not given consent, you will be tortured in the police case. That final format has been given. Man. Statement once made, he preferred the rule prudence by detection. Hence, the cornerstone of a valid confession is the only whether such a statement of complies the statutory provision which made before magistrate. Confession can be acted upon if the court, paragraph 24, my lord, that part 7. Confession, sub-para 7, my lord. Confession can be acted if the court satisfied that they are voluntary thereto. The voluntary nature of confession depends upon whether there was any threat, inducement, promise, or it is just to the in the context entire prosecution case. The confession must fit in proof fact, not run counter to them. When the voluntary character confession is truth or accepted, it is safe to rely on. Indeed, a confession is voluntary or true, not made under the inducement. The most patent piece of evidence is maker retracted confession, however, stand. The Privy Council on state. In India, it is ruled that confession to find a retracted letter. A court may take into account the retracted confession, but more to look for the reason for making confession as well for retraction. There must wait to determine whether retraction affect voluntary nature the confession or not. If the court is satisfied that it was retracted because all thought or advised the retraction may not wait for the court. If the general proof, the circle, all the same, the court do not take upon retracted confession without finding assurance from the other sources guilt of the accused. Therefore, it cannot be stated true confession made voluntary may be acted upon the evidence called retracted confession required to general assurance, and retraction was afterthought that earlier statement was true. Sometime, what happened, my lord? He has given confessional statement. He was sent to the judicial custody. When charge has been framed, my lord, he was produced before the court, my lord. Several times charge has been framed. At the time of, my lord, examining prosecution witness, no suggestion has been made. Ultimately, in 313 statement, 313 statement, my lord, on later stage, he retracted the confession. In his case, my lord. Then, my lord, what is that thing here? As already I discussed, that because he was led by the prudent lawyer, my lord. So he retracted the confession. It should be voluntarily, he should retracted the confession. My submission before your lordship is that immediately after confession statement has been read. After 2 years, 330 statement, that will, my lord, not help to the prosecution, my lord. The objective is explored by the court at various wherein it has been noted that provision permit confession statement criminal time from a chronological and a confessional statement of the petitioner dated 2011-2010. And as the preliminary examination held 1911, it is apparent that the minister duly complied with all procedural requirements according confessional statement effectively satisfy himself. Then 26.3. After preliminary question, the petitioner was entrusted sent back to judicial for reflection after duly informing that he was not under obligation to give confessional statement. The petitioner responded before did on the next day, again opposite to change his mind and not the confess. The magistrate one more satisfied himself is voluntariness of the petitioner and in the absence of police influence. That is important, man. That, my lord, 26.3, my lord. The magistrate once more satisfy himself of the voluntariness of the petitioner, absence of any police influence. This is just done in the instant case. Hence, it is clear that adequate opportunity reason was provided and magistrate ensured that any possible lingering effect of alleged beating of psychological stress post-encounter would have been mitigated. It is also apparent that magistrate duly informed the petitioner about the repercussions of this confessional statement, which was done in the instant case also, my lord, and made no false assurance helping his case, as in state of Assam Rabindranath Guha. The statement once recorded thereafter read out to the petitioner signed be correct. Here each and every page he has given, my lord, some impression. The magistrate signed statement 430, 230, after a sent to the judicial custody. The magistrate does was fully conscious statutory obligation, textually ensured the petitioner was not sent to the post of confessional statement. It was further stated, petitioner kept in judicial custody almost 20 months after the confession of our course, which was more likely of being entrusted to police. Still no protest or attempt detected made by him. 2 years, my lord, he has not detected the confession. The fact of the application to record the petitioner statement by IO in concept petitioner neither police custody nor acknowledging police official interacted judicial is a far better use of the police. Further, it is essential to note that petitioner failed to put forth any protest against the confessional statement, paragraph 27, my lord, having multiple opportunities during the course of trial, paragraph 27, my lord. He has got multiple opportunity at the trial. The court has held in Sankaria the retraction must be made by the accused as soon as possible. Otherwise, there is a strong presumption of voluntariness in the confession. Presumption has been made, my lord. Last time he said otherwise, my lord. Presumption has been made against us, against him, my lord. Presumption has been made that if he has not detected immediately, the presumption that he has made statement voluntarily. The confession was not challenged at this stage of framing of search. Next, my lord, the confession was not challenged during the stage of framing of search over course of examination of 47 prosecution witnesses, but instead only disputed the letter written in secret just before the examination under 13 of the court, CRPC. It is evidence that retraction at the fact end of the trial was not necessary, but rather meticulously, formulaically, perhaps as a part of defense strategy, which has been done exact in the instant cases, my. Hence, therefore, there are no the voluntary confession 2011 or it unaffected. That apart from the confession where they treated the original, till the original confession can be relied coupled with the rule regarding use of retracted confession noted by this court in Subramania Garden, Madras, that has been mentioned. Next paragraph 13, my lord. Still further, it is clear that even the retracted statement, the petitioner has made substantial admissions which led together prosecution convict them. Though the letter 25-7 merely reiterated the confession, although he agreed to be placed, the only concern and show about equal. The petitioner has attempt to justify retraction by stating that he had told to the magistrate, but his statement was not recorded to, hence the magistrate approach 164 is incorrect. A comparison of the retraction with the confession on dated 2011 shows that it is merely an improvement. The petitioner has admitted all general circumstances of the incident present in the scene of crime, being for a co-accused offense claimed by, however, is merely contended that the crime were committed by accused, not by the petitioner himself, regarding their sufficient admission 25. Moreover, we must note that petitioner has not been convicted, court below correlation of the conviction is statement, the confession made court enough evidence and shows that independent of such confession, the court had independent representation evidence. Something not important, man. So at last paragraph 66. Even if the cases involved confession merit some leniently confession, however, earlier not the majority opinion, then the majority opinion, this is the majority opinion. My humble submission before your lordship is that I have also showed some the time of reflection. I saw 2 hours. He said 24 hours, 2 days, 3 days. My humble submission, if your lordship go to the Ashwini Kalita case, my lord, even my lord, that case also, my lord, Ahung Angsa case, my lord. Important is satisfaction of magistrate is important. Second thing is that my lord, when he retracted the confession, that is important, my lord. Here in the intent case, he retracted the confession as per 313 statement. 313 at the time of 313 statement. He never retracted the confession at the time of framing of search, at the time of my lord examining the witnesses. More important thing is that the PW6 and PW8, when he was cross-examined, they are not put the question that this confessional statement was taken on my lord threatening the accused person and my lord by coercion. This confessional statement has been taken on coercion. And one thing is important, my lord, I have argued before your lordship, both this person has said that he was produced from the judicial custody. That was not denied by him, my lord. Both the 6 and 8, both the person has said to be produced from judicial custody. I could not got an opportunity to go through the record, my lord, but one thing, the last evening when I, my lord, got opportunity to go through the record, I found, my lord, this case number is criminal case number 39. PSK. One of the, my lord, the order sheet, it was like the 40 of the 2015. I don't know, my lord, what is available in the record, my lord, because, my lord, it was not the case. This was not prepared by the, my lord, registry. Paper was not prepared by the registry. I am not question the authenticity of the same, but I also is not. So at the same time, I am not, my lord. I am submitting before your lordship that I am not get, my lord, the paper book which was prepared by the registry. So record verification is important, my lord, before passing the judgment. That is my humble submission before your lordship. And one thing, he sought some judgment. All this judgment, he has not given me any citation, my lord. He has not mentioned, so I cannot rebut this judgment, my lord. This is the law. And as per my submission before your lordship is that if your lordship go by this law and evidence, my lord, that the basic fundamental thing 164 statement was not detected after the recording the 164 statement, and that safeguard has been given under the High Court has been 164 statement. That safeguard was, my lord, never asked in his, my lord, cross-examination of the suggest that this statement was taken of coercion and other. And section 27 statement, my lord, that was not also, my lord, he has said this statement was fabricated statement. It was not correct. That was not available in his manner evidence. So my humble submission before your lordship that this petition may be liable to be dismissed by this honorable court, my lord.
My lord, whether the submissions which he has made is because on the he has mentioned that he has not seen the record. So these submissions are beyond records, my lord. Because this plea he's time and again he's taking that I have not seen the records. I have not seen the record, but he has consumed 3 hours of judicial time. So whether this 3 hours submission was beyond record or not, my lord, that needs a clarification. This is one. Second, My lord, in a similar case, state of Arunachal Pradesh, division bench matter, the learned counsel was appearing. I was the counsel for the accused. Because we want to assist the court, we give paper books. The records are there before the court. Similar view was taken that appeal was allowed. With that plea, they went to the Supreme Court. Supreme Court take 2 minutes to dismiss it in limine. Let me put it on record. The case number is Ramesh Thakur. He knows it. So this sort of plea I'll not take up in an appeal. The record is there. Nobody is stopping anyone from checking the record. Even I have checked the record. I have flag marked under 2007 CRPC. The accused gets some copy. Those copies are handed over to the council, and that is how the council gets this copy. What interest the council will have in making some other? This is just doing to assist the court. He could have done it well. So if my fault is that I have done something to assist the court, giving page number and everything, then I take it on my stride that yes, I have committed a mistake in assisting the court. I have also should have sat idly and made submission that records are there, because my man is behind the bar. And it is from 2016, 17, 18, 19, 20, 21, 22, 23. 7 years, my man is behind the bar. Therefore, I have urgency. They can take all this plea for another 10 years. If the paper books are not made, you will say the paper book has not. I have not stopped it because this submission he has repeated. Therefore, it needs a response. Same plea he has taken in Ramesh Thakur case. There were 6 eyewitnesses. The division bench of this honorable court allowed the appeal, acquitted them. They take that plea that the paper book was prepared by the council. The court said it is in the record. If there is anything you show from the record that it is a manufactured or it is this. They went to Supreme Court. It was dismissed in 2 minutes. Not even notice was issued.
My lord,
Anyways, I'm coming.
I am not
You are done.
asking, I am not asking
No, no,
about
apne
the,
to-
no, I am not asking the authenticity of the case. But surprisingly, one thing is that this council always tried to argue the case without verifying the paper book from the section, my lord. That is why I am submitting before your court. He is submitting, my lord. I am submitting many things against him, my lord, before this court.
Yeah.
Let him submit one thing against me.
Good. He
Your
has
lordship can
he has
verify
an
that
issue.
word
He has
also,
an
my
issue in
Because
making paper book.
I don't want
The
to
moment-
pinpoint something.
He has an issue in making a paper book.
This was proceed.
Yes, I'll proceed, my lord. But
Proceed.
that is what, my lord, I don't want to go into this. What paper book who has made, it is there, the record is there for everyone to verify. Now, yes, my lord. My lord, every time when the council have referred my submission, he has either he have not noted down my submission or he had forgotten what I have submitted. Live streaming of our arguments are there. He can go and verify it. He said that I made a submission regarding 164 that the presumption is against the prosecution. But rather he said the presumption is against me. He said he has put words on my mouth that I made a submission while referring to 164 that there is a presumption which goes against them. I have not argued presumption in relation to 164. I have argued presumption in relation to 114 of the Evidence Act. That too, because the seized articles which were somewhere sent to FSL, FSL report was not produced. Somewhere not sent to FSL, and none of the seized articles were produced before the court. In that relation, I say that a presumption under 114G would be drawn against the prosecution. I'm surprised and appalled by such submission where, my lord, I have no problem when somebody is arguing on the merit of the case, but putting words on the other side counsel mouth is not at all appreciated, my lord. There is live streaming. It can be cross-verified whether I refer to presumption under 164. Coming back to the arguments which he has made, I'll demonstrate from the record that these arguments by no stretch of interpretation can even be remotely applicable in the present case in hand. My lord, let us in principle agree to certain broad proposition of a criminal law, my lord. Number one, my lord, in criminal law, the law takes its color from the fact. There is no straitjacket law laid down in no straitjacket law in criminal jurisprudence, my lord. In some places, your lordship will find 24-hour reflection time was not sufficient. In some places, your lordship will find 2 hours reflection time is not sufficient. In some cases, my lord, probably 3 hours reflection time is sufficient. Every case has to be judged on the facts of that. Therefore, my lord, at the inception of my argument, if your lordship remembers, my lord, I said that this man was not properly defended. I made that submission on the first day when this matter came up before your lordship, because I don't see, my lord, forget for the time being, PW5 or PW8. None of the witnesses were being effectively cross-examined. This man is languishing in a jail far away from his home, my lord. He has not even got the benefit of bail. He was in custody. He doesn't know which counsel. Probably he is not even in a position to assist his counsel. He is a man who puts his thumb impression, my lord. He's not an educated man. He knows about retracted confession in 1973, what Supreme Court laid down, and 2005, what the division bench and full bench have laid down. No, my lord. At the end of the day, my lord, all these laws has to be applied in the contemporaneous facts. The law has to be applied in the contemporaneous fact. What are the contemporaneous facts of the case? The contemporaneous facts of the case is that this man was arrested. He was given 4 days of police remand. No medical examination, nothing. He was produced on 29th, 11 o'clock. No warning, nothing was given to him at 11 o'clock. He was asked to produce again at 4:15. 4:15, the magistrate gives some the warnings in English in printed from and everything. He gives those warnings at 4:15, and 4:30, he records the confession statement with 15 minutes reflection time. This is the attending facts. Now let us try to apply the law. Otherwise, law will remain in theories, my lord. That is precisely what there is no straitjacket law. I have not found, my lord, in my limited experience, in my whatever limited study I have done, my lord, I have not found a straitjacket. There is, for that matter, in no aspect of criminal jurisprudence. My lord, paper book. Yes, my lord, my paper book, page number, paper book to my lord, what is the weapon of murder in this case? The weapon of murder is the seat belt. He was killed by strangulation in the seat belt. I was expecting that the state would indicate that, because, my lord, the state will also have to save my interest. I am also a subject of the state. I thought that the state would indicate that. Now, why I am indicating that? Kindly see. My lord will kindly come to page number 57 of my paper book, the scissor lead by which the seat belt that the weapon of murder was seized. Page number 57.
Yes.
My lord will see the date of seizure kindly, my lord. 25/12/2016, it was seized. Seat belt. From where it was seized, my lord will see. It is written in page 57 itself. After accused Suman Biswas disclosed that he had murdered such and such by strangulating him with the seat belt of driver's seat of car such and such, then your lordship will see. In small words, they are trying to accommodate some line in between two lines. Accordingly, belt has been seized from the car. So the belt was seized from the car on 25/12/2016. Am I correct to that extent, my lord? It was seized on 25/2016 from the car. Now, out of these two seizure witness, nowhere this Lima Mozang says, that is PW1, that the seat belt was recovered in my presence, and that I have that the seat belt was recovered in my presence. He nowhere says that, my lord. Page number 57. I'll just verify the page 57. That is exhibit 15. He nowhere says that he has signed exhibit 15 in his examination before the court. Now, my lord, why I have shown the place and now 25 they examine. When they seize the car, my lord, page number 49, my lord will kindly see. They seized the car on 22/12/2016 at 12 o'clock. Then this car is taken to the police station. Inside police station, inside police station means in the police premises, this belt was recovered. This belt was recovered after 3 days. Why they did not recover the belt on 22, the murder of the offense? Because according to them, this strangulation was done by the belt, and even PW1, whose evidence he is relying on, that PW1 says that I've seen the dead body of my brother on the neck, which was tied at the seatbelt. There was a mark on the neck which shows that his neck was tied by the seatbelt of the vehicle. I have also seen blood stain on the abdomen area. Marking here that the seatbelt was cut by a dowel. I found somewhere. So the seatbelt was not attached, probably. I found somewhere that the seatbelt was cut by the dowel. I have come to know that the police have observed the procedure. Mark of passing information could be found. After about few minutes, one information is received of by standing near the TR camp and one dead body inside the vehicle. On receiving the information, probably in the evidence of the PW8, that seatbelt was PW8. His younger brother was serving as a. During interrogation, I visited the post office. His sample here were found inside the car. The wife of the deceased. On analysis of the, accordingly, I prepared the accused person, Suman Biswas. I apprehended. The accused person has admitted that he has committed the alleged offense. I took the accused, he identified the footprints and stated that said footprints belong to. Accordingly, I have seized the shoe. The accused during interrogation of the case stated that while committing the, he thrown the Nokia mobile and the handset in the procedure. He had also stated that the dowel stabbing was thrown by him after the commission of the crime. As per disclosure, I took the PO, and on his assertion, I have recovered the Nokia mobile handset, the dowel from the jungle from the place of occurrence. I seized the cloth of the accused, which were owned during the time of commission of the crime. Later on, the seat belt of the car belonged to the deceased, and also the seat belt was weapon of the offense. My lord is there at page 31. Seat belt was the weapon of offense for causing death of the deceased. After obtaining CDR of the phone number belongs to the accused, it was found that they have some illicit relationship. The accused had admitted having illicit. As per the evidence, in the morning, he called the wife of the deceased. He asked the deceased left the resident empty junction and boarded on the car of the and proceeded to TRK. On the way, deceased and the accused have some argument regarding the illicit relationship of the accused with the wife of the deceased. During that time, the accused has committed murder of the deceased. I had forwarded the accused Suman Biswas before the magistrate for recording of his confessional statement. On being confessed, the statement is recorded. On completion of the investigation, I have found that the offense under 203. My lord, it is there. I'll indicate it is there that he has cut the seatbelt with the dowel, my lord. It is there. Somewhere it is there, my lord. I have informed the police that when my brother was driving the car, there was argument between the still. I have killed with the accused with a knife. The accused person disclosed that he has thrown the knife. As per the disclosure, Suman Biswas police has recovered the blasted and the mobile of my brother from the jungle. I have not seen the. So, my lord, be that as it may, but it is there, my lord. I'll indicate that the accused has cut the seatbelt with the dowel. Probably it is there in the confession statement, my lord. Confession statement. Down the car and tightened the belt and his neck to make sure that he is dead. After 30, I took the dowel and stared inside. I told that we were having affair. I cannot live without it. Then, once in the face, out of anger, I pulled the driver's seat belt and tied it around his neck and stayed it. Till that again, I removed the back belt behind him and cut the seat belt. Confessional statement. Confessional statement that he has cut the seat belt. Page number 44. So the confessional statement does not corroborate with the records. Page 44. Page 44. There is a space and cut the seat belt. It is in the middle, my lord. Cut the seat belt with dowel kept in the car and tighten the belt around his neck to make sure that he is dead. So it is not that the seat belt was fastened with the claim in the car. He has cut it. Why they did not seize it then? It was lying loose. They say that they found ligature mark. So prima facie, the inquest report also says why they were waiting for 3 days for for them to seize it. These are the here comes the role of inference. A thing which could have been done was not done at a particular, which could have been done is not done in the manner which it is prescribed. You will have to seize it at the earliest point of time. He has got it. Why you leave it giving chance for manipulation or somebody may tamper with it? They should have seized it immediately. Now, my lord,
I shall give an
Yes.
explanation, ma'am, later on.
দিব দিব
Explanation, then did you?
মই কৈ লওঁ মই আপোনাক শুনিছো। Now, yes, my lord. As far as the fact that the dhow which was recovered and which was not produced before the court, what would be the implication of this? My lord, in a criminal case, the prosecution cannot rely on the defense of the accused. They will have to stand on his own feet. These are time-tested proposition of law, my lord. I cannot argue a criminal case on behalf of the prosecution, and the thrust of my argument is this: some advocate which he has engaged while he was in custody did not make this suggestion, X suggestion, Y suggestion, Z suggestion, and therefore convicting. They will have to stand on his own feet. Then the burden will shift on me, provided they establish the. Now, here, in order to bring home the guilt, what are the evidence they're relying on? They're primarily relying on two pieces of evidence. That is the disclosure statement, undated, even the attesting witness was not examined. To lend some credence for the sake of argument, assuming and not admitting for a while that this disclosure statement has been observed, following all procedure, everything correct, 100%. Can a conviction be based on a disclosure statement? Answer is no. It needs corroboration. In a circumstance, in a case based on circumstantial evidence, my lord, if there are ocular evidence, case is different. In case of ocular evidence, prosecution need not connect each and every circumstance, my lord. They need not prove each and every circumstance so as to form a chain of circumstance, because there are ocular evidence to support it. But in a case based on circumstantial evidence purely, it is incumbent on the prosecution to establish the chain with cogent and unimpeachable evidences. They cannot rely on the defense suggestions and the skill of an counsel at the stage of trial, my lord. He has relied on one or two judgments. In those judgments, my lord, the FSL reports were there. Sufficient reflection time was given. That is why, my lord, I say that law has to be applied on the attending fact. The judgments which I have relied, I have noted out from my lord, from my mobile, from Supreme today. I have checked. In most of them, one by one, I'll deal with them as well. Most of them, there were FSL report, sufficient reflection time, all warning done. This. I have not found a single case relied by the worthy counsel for the state of Arunachal Pradesh, which shows that after 5 days of police custody, 15 minutes reflection time was given and the conviction was upheld. I am sorry, my lord, I'll be stand corrected again. I have not come across a single judgment relied on by them to that proposition. My lord, did I ever argue that in this case, Section 27 statement was not recorded and therefore it cannot be taken into assistance? I never argued it. Much time was labored on impressing your lordship that is in Section 27, recording of a statement is not recorded. I have not even argued it. What I am saying is that the Section 27, which is recorded and exhibited, does not inspire confidence because of three things. One, it is undated. Only the date column is kept blank. Only the date column is kept blank. There is only one attesting witness. That witness was deliberately withheld. And there is no mention of the seatbelt. in the disclosure statement. If the disclosure statement had any nexus with the offense, then the disclosure statement would also have contained a reference of the seat belt, that I have kept the seat belt inside such and such, such and such. I am attacking that on this ground. I have never ever argued that it is mandatorily, it has to be recorded or it has not to be recorded. But I will show, my lord, what the full bench of the Honorable Supreme Court last year, 2021, have laid down the principle of criminal trial in one judgment. It was a reference judgment where the Supreme Court has shown the principle of criminal trial. And while laying down the principles, my lord, with regard to section 25, the full bench of the Supreme Court, this only 2021 judgment. No, that one, yes. I'm giving the citation number. Justice S.A. Bobde, Chief Justice, Nageshwar Rao, Justice, and Justice Ravinder Bhatt, 3 judges. 2021 10 SCC 598. My lord, this is a mini CRPC. And I am relying on paragraph 11 of this citation, internal page number 610. I'll just read it, my lord, because just now I bought it. I could not get the 2 copies, my lord, because I'm told that from court we cannot get printout, my lord. I'll read it and then I'll give the judgment, my lord. It is only 4 lines. The presiding officer shall ensure that only admissible portion of section 8, section 27, that is recovery statement, section 27 of the Evidence Act is marked, and such portion alone is extracted on a separate sheet and marked and given as an exhibit number. 2021 latest 3-judge bench decision. So, my lord, subject to correction, my lord, even that proposition that it need not be in writing, which has been followed in the other cases prior to 2021, probably this proposition will hit those observations, because it clearly says not only record, but it says that particular part of the statement has to be extracted in a separate piece of paper, and that has to be separately exhibited. Judgment to the copy.
My lord, I have to clear
At 2.
at 2 months.
Lordship has 2 more matters relating to the state of Assam. Lordship has a single bench also, and my mother-in-law is also admitted in the hospital. So Lordship, she is there, she can do 1 matter, but then Lordship has a single bench also.
Yeah, maybe this will be the last case.
Lordship can then take it over next week.
Vehicle has been recovered, and that vehicle has been taken to the police station. Thereafter, my lord, the accused Suman Biswas was arrested, and he discloses before the police that by the seat belt, by strangulating him by the seat belt, he committed murder to the accused person. That was mentioned in the disclosure memo. On the basis of that, from the inside of the vehicle, that seat belt has been recovered. My learned friend has said earlier they should have to seize the seat belt. My humble submission before your lordship, how can the investigating authority know that by this seat belt they have committed the murder to the deceased person? That is my submission before your lordship. That is a practical thing, my lord. The vehicle has been vehicle has been taken to the police station. Thereafter, accused was arrested. His 164 statement, his disclosure statement, he says categorically stated that by the seat belt he committed murder, and on the basis of his disclosure statement, the seat belt has been seized by the investigating authority. That is the thing, my lord. And others, so far the Dow is concerned, it was seized from the jungle, my lord. That is my submission before your lordship. Regarding other part, my lord, what should I submit, my lord? As per law, what has been stated by the Apex Court, my lord, I am submitting before your lordship, my lord. Law has said if you are not cross-examination, you did not cross-examine the witnesses, that means the evidence can be accepted. That is my submission, my lord.
We cannot keep on waiting for him. We'll conclude the argument.
No, now I'm gonna hear the-
Okay, so we can put it down. There's no point of that. Have you called him?
Yes, Lordship, I called him.
He has said that he has no ignorance about the, my lord, procedure prescribed in the law. That will not help, my lord, in criminal trial, my lord.
Not inside the courtroom, Mr. Biswas.
My lord.
But I'm extremely sorry. I went to chamber to get these books, my lord.
You make your submission short.
Absolutely, ma'am.
Practically, there's nothing much to hear more.
Absolutely. Absolutely. My lord, some of the judgment which he has relied, especially the latest judgment, I was astonished to read the facts. Both these judgments are death reference cases, where a minor girl, in one case, one minor girl of 8 years was kidnapped, raped, murdered. Death reference was given by the confirmed by the High Court. Supreme Court reduced it to 30 years of life imprisonment. Proposition laid down in that case is sought to be relied on this case. The other case, which the worthy counsel have relied, my lord, in that case, two school-going girls, 7 years and 10 years, were kidnapped, abducted, kept in captivity, raped, sodomized, murdered, 49 witnesses examined, forensic report collaborated, eyewitnesses who have said that they have seen the act of abduction. Eyewitnesses were there. In that context, Supreme Court says this sort of deficiencies or discrepancies in evidence will not be of any help in a case of this nature. The fact was not placed. Only those paragraphs where the law was laid down, where the proposition of law was said, your lordship's notice was brought to those paragraphs. To be precise, this was one judgment which he relied. He has given the copies, my lord can revisit those two judgments. 2022 8 SCC 668. The lordship will find that judgment.
2022
8 SCC 668.
Yes.
My lord, this was a death reference, your lordship will see. Now, this judgment was pressed in service to show that defective investigation cannot be a ground for acquittal. My lord, what was the defective investigation in that case? In that case, the defective investigation was that the DNA profiling was not done in accordance with law. Your lordship will see, this is a death case. Kidnapping, child rape, 8 years, murder. This is a last seen theory. And in this case, the evidence of the relative of the accused. The relative of the accused gave evidence against the accused in this case, 2022 8 SCC. They said that we have seen him going with the girl at night. So, my lord, rest I leave to your lordship, my lord, whether the proposition laid down in this case can even be remotely applicable in the present case at hand. It's a death sentence case. Your lordship will see that eventually, even despite all these things, my lord, such a heinous offense, but the Supreme Court has reduced the death sentence to 30 years, they say. The other judgment which this judgment was placed to say defective investigation. For that, this judgment was placed. Now, the another judgment where he paid much reliance to show that 164 statement, voluntariness, this and that, my lord, that judgment is 2025 SCC 782. My lord will kindly see. Luckily, I got that 30-minute lunch break, my lord, because that gave me an opportunity to read these judgments. 2025 SCC 782. Much reliance was placed on. My lord will just give a cursory look on the head note. This is such a heinous offense where the death penalty was upheld. 2 minor girls, 7 years, 10 years, kept in captivity, raped, sodomized, killed by throwing them into canals. My lord will see para 13 of this judgment. What were the evidence available in that case? And whether even an iota of those evidence are available in this case or not. Para 13, my lord will see. 2020, because much reliance was placed on this case. Para 13, my lord will see in this case. If your lordship is holding the SCC printout, then case history, para 13, my lord. Over the course of the trial, the prosecution examined 49 witnesses in all, including person who witnessed abduction, purchase of milk and cow dung powder, and those having seen children in the custody of the accused at various places. This judgment is relied in a case where not, and moreover, my lord, in this judgment, they have relied forensic evidence as well. Further, various medical and forensic evidences were produced. The next slide. Two minor girls. It will shake anybody's conscience. The father was in Coimbatore. And they were, because here retraction was done in 313, Supreme Court said they were not remorseful. They were not even repenting. And therefore the retraction was not taken into, and the Supreme Court said these are belated and all these things. In this background, my lord, in this factual background, which is why, my lord, I said that every law has to be, my lord, especially in criminal jurisprudence, my lord, the law will take its color from the facts, my lord. Devoid of the facts, the law will not be of any use, my lord, of any help, my lord. The other judgment which was relied was 2009 2 GLT 414. My lord, I don't want to I don't wish to make any submission on that, because that was precisely on the point, Justice Ansari's judgment, that was precisely on the point whether section 27 has to be in writing, whether it has to be recorded in writing. That is not my case at all. Whether it has to be in writing or oral will do, this is not my argument in this case. So I will not waste my time there. Now, my lord, now, my lord, it was argued in this case that I had not given any suggestion. In other words, if I understand correctly, ineffective cross-examination. the cross-examination was not very effective. And since the cross-examination is not effective, no suggestion was given. Therefore, whatever is written in the examination in chief will has to be accepted as gospel truth, will be admitted, will be constituted as an admitted fact. And therefore, my lord, no interference is required. My lord, I press in service 3 judgments of the Honorable Apex Court, which says that cross-examination is not the only tool to discredit a witness. It says that courts, to quote the exact paragraph, my lord. Yes, AIR 1969. AIR 1969. एक तीनटा देना AIR 1969, 1995. तीनटा. हाँ. AIR 19. अच्छा AIR 1981 to take. 81 to take. दे 81 to दे. 81 to दे. और ये दूसरा रेडी करो. Find out this two. These two. Para 5. That cross-examination, I'm reading the relevant para, my lord. We do not agree with the submission of Sri such and such. Cross-examination is not the only method of discrediting a witness. If the oral testimony of certain witnesses is contrary to proven facts, their evidence might well be discarded on that ground. If the oral evidence, para 5, if the testimony is on the face of it unacceptable, courts are not bound to accept the testimony merely because there was no cross-examination.
Para 5 of?
Para 5 of this judgment, this is a Manupatra printout, AIR 1981, Supreme Court 353. This is a Manupatra printout. Ara duta korta sir. Yeti konto? Ha? 59 na? Duta paste korta sir. 1, 2, 3, 4, 5, 6, 7. Ito the one is the deal. Ito ko. Ano ito? Ha? Ito AIR 1969 ko tapos. Ha? Jatuh kan sir. Itu pera number itu na? And what about this? This is AIR 1969. My lord, have seen, my lord. Cross-examination is not done.
Para 5.
Yes. Cross-exam para 5 that starts with para 5. I am reading 1, 2, 3, 4, 5, 6, 7. The 8th line from 7th line. We do not agree with the submission of such and such. Cross-examination is not the only. Court are not bound to accept the testimony merely because there was no cross-examination. The other judgment which I am relying to buttress this point is AIR 1969, Supreme Court 255. I've given a copy. Paragraph numbers are para 6. Para 6, the 3rd line. It is true that the witness examined. Para 6, 3rd line. It is true that the witness examined on behalf of the appellant have not been effectively cross-examined. It is also true that the collector had not adduced any evidence in rebuttal, but that does not mean that the court is bound to accept their evidence. The judges are not computers. In assessing the value to be attached to oral evidence, they are bound to call into aid their experience of life. As a judge of a fact, it was open to the appellate judge to test the evidence placed before them on the basis of the probabilities. The prosecution cannot take help of ineffective cross-examination. They have to stand on their own leg, more so when the case is purely based on circumstantial evidence. Just because there was that, and on the first day I said, my lord, this man was not even defended properly. And there is one more, that is 1995 2 SCC 307. This is again. Huh? 1993. Hard copy, 1995. 1995. That one. My lord, I'll give a copy of this. My lord, I'll just read it. My lord will pardon me because hurriedly I got the Xerox within half an hour because those arguments came up, my lord. I'll give that the citation is 1995 2 SCC 305. 1995 2 SCC 305, para 16 and 17. Para 16 and 17. This is precisely on the point that failure to do, that if cross-examination is not, if in absence of any effective cross-examination, it is not that the evidence has to be believed in its entirety. It has to be looked into the other attending facts. Therefore, in one of the judgments says the judges are not computers. That no cross-examination, something will pop up. Yes, cross-examination, something else will pop up. No, it has to be seen from the lights of the case. This has to be appreciated, keeping in regard the other evidences which has been collected and the records of the case. My lord, this judgment I'll give during the course of the day. 2021. That already I have given that citation, that section 20, that is on the section 27. Only that incriminating part has to be extracted and a separate. That is the principles laid down by the court, by the full bench of the Supreme Court, 2021 10 SCC 598. This, my lord, I'm not relying much on. I'll save time, my lord, but just for record, I'm giving it to your lordship. In fact, this judgment lays down how the criminal courts should conduct a trial, my lord. That's a reference of the full bench of the Supreme Court. Now, yes, coming to the other point, my lord, on the last occasion, I argued that point, that what would be the effect of, what would be the effect of non-production of the weapon? Because here is a case where the weapon is still in theory. Caesar Lee says weapon, and it is not that something very bulky thing was seized. I can understand a truck being seized or something else being seized. It is a weapon which could have been easily carried. This weapon should have been bought during the trial. It should have been shown to the witnesses as a material exhibit. The witnesses should have identified this, because this weapon is a vital piece of evidence which the prosecution is trying to use against me. Therefore, it is incumbent on them to show it to me when I am in the dock under 313, show it to me, elicit my answer from that is it the weapon? I may say yes, I may say no. To what extent this proposition has got legal, sanctity? In that regard, my lord, I am relying on few judgments, my lord. This is one 2011 3 GLR 495, weapon not produced during the trial. Para. I'll just cut short, my lord. I'll try to make it only those specific area.
No, citation do you want?
2011 3 GLR 495. My lord will straightway come to the last page. The last page, para 7, last line. Para 7, last line. In fact, the investigation officer, though seized the said torchlight during investigation of the case, the same was not produced before the court at the trial for its recognition either by PW8, the first informant, or by the investigating officer. In a catena of decision in such nature of cases, the means of recognition and the weapon of offense are required to be produced at the trial to facilitate the trial court to arrive at a definite conclusion that by means of those materials the assailant was recognized and the injured was assaulted. the weapon of offense and means of recognition being not placed during the trial for recognition by those material witnesses, claim of PW8 that he recognized the assailant by means of the torch he was carrying cannot be acceptable. Further, the weapon of offense, which was alleged to have been seized from the possession of the appellant, was not produced at the trial for recognition. This also makes the prosecution case shaky to a considerable extent. The next division bench judgment of our High Court, thou not produced before the court, seized, not produced. This is 2010 to GLR 383. This is a division bench judgment.
Argument
Para 21, my lord, will come. The last page, para 21. Para 20, this is a division bench judgment.
Yes.
Para 21. As noted above, the learned trial court has based the conviction of the accused appellant on the purported incriminating circumstances against him without, however, focusing on the most vital aspect of the matter as to whether such incriminating circumstances have been clearly established by relying and clinging evidence, by reliable and clinging evidence. It cannot be said to be a case of proved circumstance following a chain of events from which the only irresistible conclusion which could be drawn is the guilt of the accused. Even assuming that the information furnished by the accused appellant lead to the discovery of a thou, that by itself cannot be the ground of conviction. At best, the same could be the ground of foundation of the prosecution case. It is only one link of the chain of the proof, but the other link forming the complete chain are absolutely missing, and the prosecution has miserably failed to forge the same. As far as the thou is concerned, para 17, my lord will see. That is the conclusion. Thou is concerned, para 17. At the first instance, the purported statement of confession made by the accused appellant before the police is of no consequence. Secondly, there is nothing in the statement of PW 4 and 8 that thou which the accused appellant had purportedly produced was the weapon used to commit the offense. Even if we believe the accused appellant had produced a thou, the conviction could not be sustained solely on the basis of the same. Further, the seized thou was also not produced before the trial court during the proceeding. So even if, because this thou has to be connected with the accused, and there were evidence to connect, and there were opportunities to connect him, because his fingerprints were taken. There is a Caesar list where the fingerprints of the appellant was taken. They say it was sent to FSL. Why the FSL report? They could not wait for the FSL report, and why it was not submitted. So without that link, now PW1 say that there was blood stain in the thou. If there was blood stain, it would have been a golden opportunity to send it to the FSL chemical examination, and the blood sample of the deceased was also taken. Then the weapon could have been connected with the deceased through the blood sample, and the appellant could have been connected with the weapon through the fingerprints. That would have formed the chain. Now, one more, my lord. 2013 3 GLR, Guwahati Law Times, 260 page, para 8. Para 8, 1, 2, 3, 4, 5, 6, 7, 8. 8 line from bottom. The said knife. Eight line from bottom, the said knife. Eight, the said knife. Para 8, the 8th line from bottom. The said knife, although seized by the police, was not produced before the trial court, and it was never exhibited. There is no evidence that any fingerprint was taken from the aforesaid knife seized by the police. No explanation has been offered by the prosecution as to why the crime weapon seized during investigation was not sent for FSL test and why the fingerprint was not taken. If the fingerprint was taken, it could have been verified whether the crime weapon was held or used by the convict petitioner. Further, if the knife was sent to FSL test, the prosecution could have been able to prove that it contained human blood, and it could have been proved whether the blood contained in the knife belonged to or tallied with the blood of the victim. That is precisely what I have submitted. This is how it has to be connected. Now, this is another judgment, my lord. This was a division bench judgment, 2012, 2 GLT 112. This was in fact much better case, 2012, 2 GLT 112. This is the judgment, my lord. This was in fact a better case because here at least the dove was sent to forensic and the blood group was tallied. This is also a division bench judgment, my lord. The then Chief Justice, Justice Adesh Kumar Goel and Justice C.R. Sharma. Para 15 of this judgment. Sri Prasanna Kumar Kalita, Senior Scientific Officer of Forensic Science Laboratory, deposed as PW8. He examined a blood-stained dove and a piece of cloth and came to the finding that the said articles contain human blood of group AB. He has exhibited the report as Exhibit A. The said report does not indicate that the blood group found in the dove and the piece of cloth aforesaid was the blood group of the deceased. It was rather a better case than this because here at least the initial connection was established here. Connection between human blood and the presence of blood in the dove. And the conclusion of the court is in para 8, 9th line. In order to hold a person guilty of a charge, prosecution is required to establish the case beyond all reasonable doubt by adducing cogent and substantive evidence. Failure to do so would result in acquittal of the accused person on benefit of doubt. In view of the above discussion, in the present case, the prosecution has failed to establish beyond all reasonable doubt that the appellant had inflicted the fatal blows on the deceased. Therefore, we find sufficient merit in the appeal required interference. Here also there was a disclosure statement. My lord, there is one more judgment I don't wish to rely, my lord. In absence of chemical analysis of the seized weapon, there was absolutely no link evidence to connect the dove with the commission of the offense. This is also another division bench judgment. This is also I'll rely on one paragraph. Same case, in absence of chemical analysis of the seized weapon, there was absolutely no link evidence to connect the dove with the commission of the offense. This is also division bench. 2018 4 GLT 32. I am relying para 20 and 21, the para 20 last line. What therefore crystallizes from the above evidence is that circumstance sought to be relied by the prosecution were not proved beyond reasonable doubt, not to speak of proving the chain of evidence for leading to the conclusion consistent only with the hypothesis of the guilt of the accused. The conduct of the accused in appearing in the police station, even if assumed to be correct, that alone is not sufficient to prove a charge of murder without anything more, and as such prosecution. Here, the person he himself appeared in the police station. This is also division bench, my lord. Para 20 last line and para 21 I am relying. Para 20 last line, last sentence, and para 21. Finish.
Yes.
My lord will take the compilation of cases which I have given, my lord, because my lord, argument is made to brush aside the explanation which an accused gives under 313 my lord, it is contended that he could have retracted it immediately. Why at 313 stage? My lord, if I understand the criminal trial procedure correctly, subject to correction, my lord, it is only at the stage of 313 when the judges put question to the accused. Rest of the proceeding are conducted by the counsel. It is only 313 in a criminal trial, my lord. It is only under 313 when the defense, when the prosecution witnesses are closed, then the accused comes to dock and all the incriminating materials which the prosecution has collected to bring home the guilt, each and every incriminating materials are put to the accused, giving him an opportunity to explain the circumstances. Similarly, my lord, this man was for the first time, the judge put him this question about this voluntariness of the confession statement. It was under 313, my lord. And my lord, I have already made my submission as to his intellectual faculty, my lord. He is a man who puts a thumb impression. My lord, as a proposition of law, I can understand, my lord, immediately. And the sort of legal assistance he has got is evident from the cross-examination done in this present case. The sort of legal assistance he has got is quite evident from the cross-examination, my lord. Now, one, that compilation which I have given, my lord, yes. Page number 34, if your lordship comes. This has a reference. This is in connection with the submission that I did not put proper suggestions. Now, on whom is the burden to link the evidences? Para 25. With regard to section 27 of the Act, what is important? Para 25, I am reading, page number 34. This is Supreme Court judgment, my lord. With regard to section 27 of the Act, what is important is discovery of the material object at the disclosure of the accused. But such disclosure alone could not automatically lead to the conclusion that the offense was also committed by the accused. In fact, thereafter, burden lies on the prosecution. The burden lies on the prosecution to establish a close link between the discovery of the material object and its use in the commission of the offense. What is admissible under section 27 of the Act is the information leading to discovery and not any opinion formed on it by the prosecution. Next, if the recovery memo were prepared at the police station itself, then the same would lose their sanctity as held by this court. Now, my lord, will kindly come to my compilation, page 39. Page 39. This is also Supreme Court, my lord. 2011-12 Supreme Court, page 39. Para 12, my lord, will see. This was a submission made by the council and then the observation of the court. Para 12 is the submission. The learned counsel further submitted that the knife which was alleged to have been recovered was never shown to the accused or was never produced in the court. According to them, as per the law laid down by the court in such and such, the weapon recovered ought to have been produced before the court and should have been shown to the accused, but admittedly neither the weapon was produced before the court nor was it shown to the accused at any point of time. This is the submission part. Para 22 is what the court has held. In our opinion, the so-called recovery of knife and bloodstained cloth would not help the prosecution. Recovery of the motorcycle cannot be said to prove because Bhawan Singh admitted the fact that he had signed the recovery panchnama in the police station, whereas another witness such and such could not establish the recovery of the knife as he was not present at the time and the place from where the knife had been recovered. Moreover, the knife was never produced before the court and was never shown to the accused, and therefore, in our opinion, the said evidence could not have been relied upon by the court below for passing the order of conviction. No material except on CD I have seen in the record. A CD is exhibited as a material witness. The CD, it is the place of occurrence. So many material witnesses, material witnesses could have been exhibited. Sorry, material exhibit could have been produced. And material exhibit could have been produced. The hair stands, the seat belt. At least let the PW8 identify the seat belt. That yes, this is the seat belt, material exhibit such and such is the seat belt, which is the weapon of offense, which I have seized, white exhibit such and such. This is the weapon. No identification. These are all in theories. This is just the figment of Io's imagination. Nothing was produced. Yes. Now, what are the alternative hypotheses that could be generalized from a fact that if the weapon recovered is not sent to FSL, if the weapon, if no attempt is made to connect the weapon with the accused or with the victim, if no attempt is made to connect this, what inference can be taken from that is at page number 46, para number 26. Debt reference, look, 2018-16 SCC 161. Section 27 of the evidence is applicable only if the confession statement leads to discovery of some fact. My lord, the middle portion I skip. I come to the 5th line from bottom of para 26, 5th line, which starts with on the right hand side, the material object which the police is claimed to have been recovered from the accused may well have been planted by the police. Hence, in the absence of any connecting link between the crime and the things recovered, their recovery on the behest of the accused will not have any material bearing on the facts of the case. Para 27, last from bottom, para 27. There is a long mental distance between may be true and must be true, and the same divides conjectures from sure conclusions. The court is mindful of caution by the settled principle of law and decisions rendered by the court that in a given case like this, where the prosecution rests on the circumstantial evidence, the prosecution must place and prove all the necessary circumstances which would constitute a complete chain without a snap, and pointing to the hypothesis that except the accused, no one had committed the offense, which is in the present case the prosecution has failed to prove because there was no connecting link. Now, the 313, that whatever is proposed in 313, whether it is just a mere formality, because most of the time, my lord, even we have little trial experience as well. The advocates say no. So whether, but at times the accused, they give explanation, whether any importance can be attached to that explanation or it is just an empty formality. My lord, the Supreme Court in 2019, 13 SCC 289, the Supreme Court has explained the true purpose of section 313 and how the replies under section 313 needs to be appreciated in the lights of facts of the case, my lord. My lord will kindly come to page 128 of my compilation. This is the judgment 2019 13 SCC 289. The relevant paragraphs are para 19 and para 20, which your lordship will find at page 131. Because, my lord, it is only under 313 that the accused gets a real chance of interacting with the judge, my lord. Para 19, section 313 cannot be seen simply as a part of audi alteram patram. It confers a valuable right upon an accused to establish the innocence and can well be considered beyond a statutory right as a constitutional right to a fair trial under Article 21 of the Constitution, even if it is not be considered as a piece of substantive evidence not being on oath under 3132 as a piece 3 CRPC. The importance of this right has been considered time and again by this court, but it is yet remains to be applied in practice as well as we shall see presently in the discussion to follow. If the accused takes a defense after the prosecution evidence is closed under 313, the court is duty bound. The court is duty bound under section 3134 CRPC to consider the same. The mere use of the word under section 3134 CRPC to consider the mere use of the word may cannot be held to confer a discretionary power on the court to consider or not to consider such defense, since it constitutes a valuable right of an accused for access to justice and the likelihood of the prejudice that may be caused thereby. Whether the defense is acceptable or not, and whether it is compatible or incompatible with the evidence available is an entirely different matter. If there has been no consideration at all of the defense taken under 313 CRPC in the given facts of the case, the conviction may well stand vitiated. To our mind, a solemn duty is cast upon the court in dispensation of justice to adequately consider the defense of the accused taken under 313 CRPC and to either accept or reject the same for the reason specified in writing. Unfortunately, neither the trial court nor the High Court considered it necessary to take note of, much less discuss or observe with regard to the aforesaid defense by the appellant under 313 to either accept or reject it. The defense taken cannot be said to be irrelevant, illogical, or fanciful in the entirety of the fact and nature of the case, my lord. Same here, my lord, because, my lord, at the end of the day, the fact remains, witness may lie, the documents will not lie. The confessionary statement which has been exhibited before this court shows that he was produced on 29 from the police custody. And then, my lord, they say that he was sent to judicial custody, assuming that at 11 o'clock he was produced and he was sent to judicial custody. Then from the judicial custody, he was brought at 4:15, given 15 minutes time. Now, my lord, so therefore the reflection time, assuming, starts from 11 o'clock, for example. Now, can the period between 11 and 4:15 be called as a reflection time? The answer is an astounding no. Why? Because reflection, he would ponder on what? Reflect on what? He would reflect on his right, which the magistrate will intimate him, which the magistrate will inform him. His right not to make a confessional statement was intimated to him at 4:15. And therefore, the magistrate correctly said in the confessional statement that he has given 15-minute reflection time. So this to reflect on the safeguard, he got 15 minutes time. At 11, he was produced. Then again, for argument's sake, even if I believe that from 11, probably from 11, he was taken somewhere around 11:30, 12, he might have reached the judicial custody from there again, because he has reached here 4:15 from again, maybe 3:30 or 4, he was taken back. Whether before sending him to judicial custody, he was informed over his right? The answer is no. Therefore, this time cannot be said to be a reflection time. The reflection time, as correctly stated by the magistrate in his 164 statement, is 15 minutes time. Now, what your lordship would here see is whether 15 minutes reflection time and reflection time is sufficient when a person has undergone 5 days of police custody and he was brought by a police officer. And my lord, I somehow, my lord, it is my incapacity. I have not understood that sentence which appears in the 164 statement that he was in police custody for 20 hours. No date is mentioned, simply says it was in the police custody from when 20 hours. And even if he is in the police custody for 20 hours, is 15 minutes sufficient for 20 hours? and he says that the time given for reflection is sufficient for, is equal to the time he has spent in police custody. If 20 hours, if I take 20 hours, which is beholds the record, which is not that the record speaks 5 days, presuming 20 hours. So if 20 hours and 15 minutes, my lord, by what standard of mathematics 15 minutes can be equated with 20 hours, I fail to understand, my lord. These are, therefore, I have said, my lord, these are formats. You have just written this yes, no, yes, no, yes, no, yes, no, yes, no. And recorded that, my lord, these are my submissions that both 164 in this present case cannot be relied upon. Rest I have already explained, my lord. I'm extremely grateful, my lord. Your lordship has heard us patiently, my lord.
May I submit, my lord, one thing?
What? No more.
My lord, one thing, he has submitted many judgments before the court, my lord. So that is why I want to submit, my lord, something, my lord. Important thing is that, my lord, he has said that this is the death reference case. So that will be not applicable in this case. Where is that law, my lord? In death reference case, it's not, the preposition of law of death reference case is not applicable in this case. First thing is that, my lord. And second thing is that in respect of 313 statement, he want to submit, and this different aspect of the matter. If your lordship, I am not reading this thing, my lord. Go to the, my lord, the explanation given by this the session judge, my lord, from page 29, paper book 92, paragraph 42 to 40, 50, 14, 49. Your lordship is give everything. Paris has been stated by the session judge. Secondly, thing is that basically he 164 statement is a, he has rebutted 164 at the time of 313 statement. That I have already submitted judgment that at the earliest point of time you have to reflected the confessional statement, otherwise not. So far recovery point part is concerned, my lord. It was concerned 164. One thing is that, my lord, if your lordship go to the statement of PW6, it is, my lord, concrete evidence. He has given this statement. This is exhibited. It is his duty to cross-examine the witnesses. If it is not, my lord, at the appellate stages, he has take all these points. And he said in the appellate stage that this will be followed. That is my humble son, your lordship will look all this aspect of the matter, my lord. And most important is section 58 of evidence act, my lord. 166 evidence facts admitted need not be proved. It was proved. 164 statement has been given. He was not denied it. He has not stated anything in cross-examination. Now he stated all this point. What judgment he sought, my lord, that is not discovery, leading to discovery along with 164 statement. That is some witnesses have said. That is a proof is necessary, my lord. And one judgment has been mentioned here, my lord. I am not reading that judgment. That paragraph 43 of the particular judgment of the, my lord, landed court below. I shall only give your lordship that judgment. That's a good judgment. That judgment, my lord.
This will never end. We keep on submitting judgment.
Yes, your lordship is
I am done,
absolute.
my lord.
I am submitting, my lord. Your lordship is absolutely correct. That is why, my lord, first time when he submit before the court, my lord, he have to produce all the judgment. He should get only reply. And one thing is very disturbing to us nowadays. When he has given paper book to your lordship, he has paper book, he has not mentioned the citation. I have mentioned all the citations. That is helping him. But he has given hide and seek basis. That is not good, my lord. As per my submission, my lord.
Para
That judgment, my lord, 13, my lord, of that judgment.
30.
Now 13, my lord. That is my humble submission before your lordship. Your lordship is absolutely good. This is a never-ending process. He are good. He again.
And this was then something we had also heard the parliamentary judging and decision, public. Just one second.
That's all good.
Because your lordship already disposed of my petition, but
The direction is that my your lordship may kindly come to page 33, my lord.
Yes,
Accordingly, the district elementary education officer Karimunj is directed to place the recommendation of the DLC before the next immediate sitting of SLC, if not already placed. If the case of the petitioner has already been considered by the state level committee, the outcome of the same shall be furnished to the petitioner forthwith. But my lord, here in the writ petition, my lord, we have already challenged the decision of the SLC, my lord. And in fact, your lordship may ought to have your lordship's order.
but that was passed in your presence.
In fact, that is true, but that is not as per record. That's why I am before your lordship, my lord.
I don't know.
It may be before the next available SLC. my lord. In my writ petition, my lord, your
Yes,
lordship may kindly peruse the writ petition, my lord.
I've seen. Yes, Majum.
Apparently, my lord, the prayer was to set aside the findings of the SLC. Please take my lord, he's not having a relief on the order that has been passed. Actually, I do not have any objection.
Before the next available SLC, my lord, my matter baby, and in the meantime, my lord, one of the coordinate bench have already quashed the said clause, my lord. Clause 3, my lord, in WBC number 2609 of 2018, my lord.
What is it?
I have a copy of. this
Where
order.
where a person, if the deceased had less than 3 years of service
That
left.
I know. The memorandum, office memorandum.
Yes, that part has been set aside by this honorable court now.
Yes.
So his case was rejected by the SLC on that very ground itself. That was not brought to the notice of this honorable court.
But where is this SLC minutes? In the writ-
My lord, I have also annexed in the review petition also, my lord.
No, in the writ petition.
In the writ petition, my lord. That is at annexure 11, page 34, my lord. Relevant part is page 37. Serial number 9, my lord. Your lordship got it?
Yes.
As the deceased did not have a minimum service period of 3 years left to his credit after his death as per OM dated so and so, according candidate cannot be considered for appointment and hence rejected. Also, the candidate applied after 1 year,
Where's the judgment?
serial number 9.
Where's the judgment? We can set aside this.
Taking aside that SLC and remanding back for fresh.
But then in a review petition,
Well, the lordship will restore the repetition, my lord, and pass final orders in the repetition. That is,
on a different day.
yes, my lord, lordship will on any convenient date, my lord, because the issue is settled. So it will not take much time.
No, it won't come before me now. After restore it,
My lord.
it has to go before the appropriate bench. Isn't it?
Your lordship may also direct in the same
In
sense.
the,
my
in
lord.
the review.
The
also I
next
can do-
available,
I
Yes,
can
in
do
the
it.
review also.
available SLC, my lord. My simple prayer is that your lordship may direct the next available
review
SLC.
petition-
Consider my case.
But in the review petition, my lord, that SLC cannot be set aside.
So the review petition will be allowed, requiring the repetition to be reheard.
Ah,
It's not-
Even lordship.
Review petition of one.
Suggesting that.
And your
you
lordship
heard
may
my
pass the
lordship
order.
also. What? If lordship allows the review today and the writ petition can be decided by lordship also since it is before lordship and lordship had decided.
I don't know, I don't know if that is, anyway, I'll I'll recall the order.
Man,
Heard, Mr.
I
I am the counsel for the petition.
Nai pada.
Also heard, Mr.
G P for respondent number 1 and 4.
For the respondent,
1 and 4.
one and four. And Mr. R. Majumdar, the standing counsel,
2, 3 and 5.
elementary education for 2, 3 and
5, man.
5. Stop. By this review petition, comma, the petitioner is praying for review of the order dated 1/3/2023 passed by this court in WBC number 8224 of 2022 on the ground that while disposing of the said writ petition, comma, this court had remanded the matter back to the state level committee. Whereas in the writ petition, the petitioner had prayed for washing of the state level committee minutes dated
26/8/2022, my lord.
26/8,
2022, my lord.
26/8/2022, insofar as the petitioner's case is concerned. Stop. After hearing the learned counsel for the parties and on consideration of the materials available on the court, it appears that the submission of the learned counsel for the petition is correct and stop. The perusal of the prayer portion of the WBC number
8/8/24/2022.
2991, I think. No,
8/224, my lord, of 2023. WPC. number.
where is the order? Of 8224 of 2022. It is seen that the petitioner has prayed for quashing out the minutes of the state level committee held on 26/8. Accordingly, comma, this review petition is allowed and the order dated 1/3/2023 passed in WBC number 8224 of 2022 is recalled. Stop. List the writ petition. List WBC number 8224 of 2022. After 1 week,
My lord, your lordship may kindly may be date may be fixed, me,
I don't know.
my lord. Oblige, my lord.
Oh, in the main writ petition, you just write like this, in view of the order passed today in the review petition. List this writ petition again after 1 week. Cancel that part in the review.
Oblige.
Oblige.
So,
May please the Lord.
Yes,
For this review petition is by the respondent number 7 of the writ petitioner, who did not have any opportunity to. কি কথা? আমি the respondent in the writ petition. They want to change my side.
okay.
Anyway, no problem with that. It was disposed of at the admission stage. Therefore, I did not have any opportunity to contest the petition at all. At motion stage, your lordship, please to see the order is at page 38. It is about the merger of a school, page 38, my lord.
What is wrong in this order?
This order is, my lord, the dispute was raised by us. We approached the authority concerned. When the other school was made the base school, then thereafter, the authorities concerned, they inspected the matter. There was an inquiry committee. Inquired into the matter. They found that it was wrongly done. Therefore, they have corrected it subsequently. Therefore, once the dispute is resolved, there cannot be further dispute over the same matter, over the same authority once again. And secondly, my lord, your lordship, this is last part of the order. Last part of the order, your lordship directed the authority, the petitioner concerned, to take an appeal to the appropriate authority. Till the appeal is filed, status quo as on today shall be maintained. We have stated that they have belatedly filed the appeal, but the authorities concerned, namely the government and authorities, taking the plea of this order, is not doing anything, and they're depriving us from the midday meals, school uniforms, textbooks, etc. That we have stated in the paragraph.
Did you appear in the writ petition?
No.
Was
it was-
notice served on you?
No, it was disposed of at the motion stage. At the motion stage, it was disposed of.
Yes.
My lord, if I may.
Oh.
My lord, my learned senior had just pointed out about the representation which they had made before the authority. My lord, the authority is the commissioner and secretary, the government of Assam. At page 27, if my lord kindly comes to, they have made a representation before the Honorable Block Elementary Education Officer regarding their grievance. And they have not made any mention about the scheme under Shiksha Khetra. My lord, clause 19 to be precise, when there is a dispute regarding such order of merger or amalgamation. My lord, this is a very vague complaint that they have made.
Page.
My lord, page 27 of the review petition filed by them. Now, my lord, in the said review petition also, they have talked about spot verification. My lord, the evidence regarding the spot verification. My lord, whenever there is a spot verification by the authorities, photographs are taken or there is some evidence at least. My lord, that has also not been annexed in this review petition. They have taken this in their submission, but it has not been appended. My lord, we have appended everything in our writ petition, which was disposed by my lord. In the order, my lord had directed us to file an appeal before the authority, before the commissioner and secretary, because we had a dispute. That is it, my lord. I don't think, my lord, this calls for review, my lord. My lord, and regarding the midday meal and the school uniforms, it is not in our hands, my lord. It is in the hands of the authority, my lord. We have not stopped it, my lord. Huh? My lord, that doesn't come under review, my lord. The interim that we prayed for. My lord, in the order passed by my lord, which is in page 38 of the review petition, it is simply said that we should go to file an appeal because we have a dispute with them regarding the amalgamation order. Because first we were made the base school. Subsequently, they were made the base school. And the grounds were a bit frivolous. So we exercised, so we had satisfied this code based on that because of the infrastructure facility, if my lord recalls. There is an explicit provision to that based on infrastructure, then waterlogging issues, etc. My lord, that is the only order, and accordingly we had approached the authorities within 4 days from the passing of the order. We have the received copy also. On 17th, the said order was passed by this honorable court. We had approached the authorities on 21st February. The receiving copy is with us, my lord. If my lord wants,
has your appeal been disposed of?
No, my lord, they have not disposed the appeal. The authorities have not. We have duly abided by the direction of the court and filed our reply, but filed our objection, but they have not.
We have another point, my lord. The writ petitioner is the headmaster of the school. What is the authority of the headmaster of the school? We are the committee.
You are the
School managing committee. It is a school managing committee who is the aggrieved. Headmaster cannot be aggrieved. Writ petition is not maintainable. We could not take up the point because we are made parties, of course, but it was disposed of at the motion stage. We are made parties, the respondent number 7 in the writ.
Yes, state.
I pay for the state.
No, no.
Can I just point out?
My lord, if I may make one small submission. My lord, the petitioner, Moinul Haq Chaudhary is a member secretary of the SMC, my lord. So as such, we have the locus standi to file.
My lord, the order of which review is sought, my lord, at page 38. Lordship will find at page 39. Accordingly, the petitioner is directed to file an appeal again. I'm sorry, my lord, I read the paragraph before that. The government of Assam has issued an office memorandum dated 22nd September 16 on the subject of Shiksha Khetra, a scheme for amalgamation, wherein in clause 7 it is provided that if any dispute arises, the aggrieved institution may prefer an appeal before the government. Accordingly, the petitioner is directed to file an appeal against the order dated so and so issued by the Director of Elementary Education before the Secretary of the Government of Assam. And assuming for a moment, madam, the review is allowed, the matter is reheard. The final order that is going to come from Lordships is perhaps there is an appeal, go and file an appeal. It is back to square one, my lord. Even if the review is allowed, there is no material change in what is going to happen. The orders passed in the writ petition is not affecting the review petitioner in any manner. It is an appeal. The right of appeal to the writ petitioner arises from the scheme itself. With or without an order from this honorable court, he can go and prefer an appeal.
Exactly.
And that will not hamper the review petitioner in any manner. If he has a grievance against the order or against the order of the passed in the appeal, he would have his own writ petition. If they are aggrieved by the fact that we are not giving them midday meal, whatever be the grievance, that's a cause for a writ petition from the review petitioner, not a review of this order, my lord, in my humble submission. Had there been some right of the review petitioner affected by the orders passed by this honorable court, of course a review would be perhaps entertained. Allowed, not allowed is a separate issue. This is an order which says that please go and file an appeal. You have a right under the scheme, go and file an appeal. A review is not going to help anybody in any manner, my lord. If we do not pass if the government doesn't pass an order on the appeal filed by him, he has a cause for action for a contempt or for a fresh petition, whatever he deems fit. But this review is not helping anybody, my lord. It is not going to change any circumstance whether there was an appearance on behalf of the private respondent or not. This is the final order which would come from this honorable court. There is a scope of appeal. An appeal can be filed. But this review, I do not think needs to be entertained, my lord.
Or we can have a slight modification
My lord,
by
yes.
saying the hearing respondent wanted to.
Yes, let the private respondent be heard in the appeal.
That's all. Otherwise.
No
there's
difficulty.
merit in it.
We may be also
Obliged.
heard in the appeal. And in the meantime, there is the status quo order that is there
I
till the
cannot-
filing of the
I
appeal.
cannot change all this.
No. I am not asking the change. As on today itself, status quo order is not there by the honorable court. That observation. Right?
Status quo was still there.
Whether they have filed whether the government has passed an order, that is the different thing.
That order, I don't need to pass. If anybody knows English properly, they will understand everything. It's already there.
Yes.
Why should I keep on explaining what? What is your ground? You're saying that you are the.
I am the SMC of the, there are two schools, my lord. Choraimari, page 38, your lordship wishes to see. Choraimari LP school and Choraimari Mardenga LP school. I am Choraimari LP school. Initially, Choraimari Mardenga LP school was made the base school. But we have complained and raised a dispute with the authorities concerned. They don't have the infrastructure, school building and water logging, etc. And we have the buildings, aforesaid lands also, separate lands, aforesaid road link, an adequate number of students and all these things. And thereafter they inspected these things as authority is concerned. That is available before the order was passed. Inspection report page koto? Page 29, my lord. Page 29.
Okay, heard Mr. B.C. Das, senior counsel, assisted by
S.H.
Huh?
Rahman.
So for the petitioner. Also heard Mr.
P.R. Sharma.
P.R. Sharma, learned counsel for the, no,
Elementary.
Respondent number one, ma'am.
for the opposite party number one,
Number one point.
and Mr. R. Majumdar, learned standing
2, 3,
counsel. School education for respondents, 2, 3,
2, 3, 4, 5, 6.
5, and 6.
7.
And Mr. J. Bikul, and the government advocate for respondent number 7. Stop. Para. The review petitioner in the present review petition is the managing committee of Charai Mari LP School, represented by its president, and is praying for review of the order dated 17/2/2023, passed by this court in WBC number 889. It is the case of the review petitioners that when the said writ petition number 889 of 2023 was disposed, they were not heard, and that because of the order because of the order dated 17/2/2023, the school the authorities has also not provided the school uniforms and books to the students, as well as the
Midday meals.
midday meals. Stop. On this ground, the review petitioner seeks review of the order aforesaid, of the order dated 17/2/2023. On consideration of the materials available at court, particularly on the perusal of the order dated 17/2/2023, passed in WBC number 889 of 2023. This court had only directed the petitioner in WBC number 889 of 2023 to file an appeal against the order dated 31/2023 issued by the Director of School Education, Elementary Education, in terms of clause 7 of the office memorandum dated 22nd September 2016, which provides that if any dispute arises with regard to amalgamation of schools, the aggrieved institution of the public may prefer an appeal before the government in the secondary or elementary education department, as the case may be. Under the facts and circumstances of the case, I see no reasons to review the order. Stop. However, it is directed that at this stage, Learned Counsel for the opposite party number 1 submits that they have already filed a appeal before the director of before the
Commissioner Secretary Government.
Commissioner and Secretary to the Governor of Assam School Education Department on
21/2/2023.
on 21/2/2023, and the same is still pending disposal. Accordingly, the Secretary to the Governor of Assam School, the Commissioner and Secretary.
The
Commissioner
Commissioner
and
Secretary.
And Secretary to the Governor of Assam School Education Department, while considering the appeal filed by the opposite party number 1 of the petitioner in WBC 889 of 2023, shall afford an opportunity of hearing to the present review petitioner
Respondent number 7.
respond number 7 in WBC 889 of 2023, as well as to the opposite party Number one, public with petitioner in WC number 889 of 2023. Stop. The rest of the steps be taken by the Commissioner Secretary to the Governor of Assam School Education shall be governed by, shall be as directed in the order dated 17 to 2023, passed in WC 889/2023. Petitions accordingly disposed.
এটা বলছে তো authority will-
Highly obliged, my lord.
In terms of the order.
Hearing.
This, my lord, is the repetition.
Last
which was-
occasions, I have concluded my argument and also I have given my written argument in this, my lord, there.
Yeah.
Yes. I filed it in this through filing process, it has come with your lordship, my lord, written argument.
You filed your written argument.
Yes, so that to become convenient for you. I filed your 9/8/22. Details are given.
Written argument.
Yes, my lord. 9/8.
Yes, correct.
Yes, my lord. So my contention is, my lord, including the page marks also I have given so that becomes convenient and time saving for your lordships, my lord.
Okay.
In page number 2, lordship may kindly see page number 1 also. In second paragraph. The contention and that page mark I have given, then become easier, my lord. My lord. So let him make his argument. I don't have to elaborate, my whatever I have said is that. Let's see it.
Majumdar,
My lord.
you ready?
Yes, my lord, otherwise I'm ready, my lord. My lord, this is a writ petition.
But just a minute, I'll just come back after 10.
Yes, yes, my lord, my lord. Who is going to write it? Who is it?
By orders to Iba.
জীবনে দেখি যাই তো বস্তু
দেখি
এটা কি বস্তু
orders to Iba.
জীবনে দেখি যা
দাদা বন্ধুটো আছে না সানডে রিট হয়ে যায় কি লাভ তুই
না না বাট হোয়াট ইজ দ্য
বাইক কোৱা
হেৰি
জানা
কাৰ্বি দেহে কাছাৰী আলিয়া লিখা
গেলে সবকে দিয়ে নহয়
কারণ আমি তো বলছি ডিসক্রিমিনেশন না পাবো না
This is a matter, my lord, where a person who was working as the engineer in the Dibrugarh University was issued a memorandum of charge. There was a inquiry proceedings held. Findings were given by the inquiry committee. A punishment was imposed upon the petitioner. That was challenged before this honorable court on certain grounds. Matter was remanded back to the university to take a fresh look into the matter. A fresh look was taken into the matter, and thereafter, again a punishment was imposed upon the petitioner, assailing which she is today before this honorable. Now, my lord, if we go through the order passed by this honorable court on the earlier writ petition, my lord, that lordship would find at page 227.
Yes.
And lordship would like to come to page shorn of the Well, keeping only the required material, I'm trying to read the order. All the page number 231, if Lordship has, what was the case of the petitioner, my lord, on the earlier occasion regarding the same disciplinary proceeding?
Yes. 1 minute.
Para 4.
1 minute. Yes, standing counsel.
The Review University, yes, madam.
Yes.
Para 4, my lord, of the judgment I'm reading.
This page.
231, my lord. It starts at page 227.
Yeah.
And I will read page 231, my lord. Para number 4. May I read, my lord?
Yes.
On the basis of the resolution number 14 of the 332nd meeting of the Executive Council dated 24th and 16, the order dated 24th and 16 was passed by the Registrar of the Dibrugarh University, by which penalty of removal from service was imposed on the petitioner. It is also seen that the said order was passed under Article 32(6)(h) of the Ordinance of 2000, the resolution number 14 of the 332nd of the Executive Council dated 24th and 16, and the order of the Registrar also dated 24th and 16 have been assailed in this writ petition. Mr. So-and-so and his senior counsel, by referring to the provisions of the Ordinance of 2000, submits that Article 32 thereof provides the procedure for conducting a disciplinary proceeding in respect of the employees of the Dibrugarh University, and that the proviso to Article 32(6) provides that in case for imposition of any of the penalties mentioned in the subclauses G, H, and I, the employee shall not be given less than 3 weeks' time to show cause against the proposed penalty. But the notice dated 5/7/2016 of the Registrar, Dibrugarh University, does not include an opportunity to the petitioner to show cause against the proposed penalty required under the proviso to Article 32(6). The further submission of Mr. De, learned senior counsel, by referring to the decision of the Honorable Supreme Court in Managing Director ECL Hyderabad and others versus B. Karunakar and others, reported in 1993 for SCC 727 in paragraph 26 and 28, is that the disciplinary authority is required to consider, amongst other, the representation of the employee against the inquiry report, but the record produced reveals that the disciplinary authority of the Dibrugarh University had not given a due consideration to the issues raised by the petitioner in her reply/representation against the inquiry report. Although according to Mr. So-and-so, several other grounds are available, but for the purposes of this writ petition, the aforesaid 2 grounds alone are urged upon. Mr. So-and-so makes a further submission by relying upon paragraph 31 of the judgment of the Honorable Supreme Court rendered in Punjab National Bank and others versus KK Verma, that in the event a regulation is in place for conducting a disciplinary proceeding, such regulations are required to be followed in letter as well as in spirit. Accordingly, it is a submission that the proviso to Article 32(6) of the Ordinance 2000 have specifically provided for an opportunity to the delinquent to reply against the proposed penalty. Such procedure is also mandatorily required to be followed. The submissions were made number 1, that while deciding upon the inquiry report, while imposing the penalty, the reply to the inquiry report was not properly looked into. Firstly, and secondly, the ordinance of the Dibrugarh University provides that before imposing the penalty, another opportunity has to be given to the delinquent officer. Now, this is in contrast to the Article 311 as it's to prior to its amendment. That opportunity was there. Later on, it was removed by an amendment. Now, this honorable court held, if Lordship has page 237, para 19. In such view of the matter, as the show cause notice against the proposed penalty was not issued to the petitioner before passing the order of removal from service, this court is of the view that the procedure adopted by the respondent authorities is in deviation of the statutory provision of the ordinance of 2000, and as such the same stands vitiated. Further, it is also the position of law that when the delinquent employee gives a reply to the inquiry report, the said reply is to be given a due consideration by the disciplinary authority before passing any order of penalty against the delinquent. In the instant case, it is noticed that although the reply given by the petitioner against the show cause notice was shown to have been sent to the members of the Executive Council, but apart from the bland statement in the resolution 14 that the reply given by the petitioner does not disprove the charges established in the inquiry, no material has been brought on record to indicate that the disciplinary authority had given a due consideration to the said reply. From the said point of view, also a procedural aberration is found in the method adopted by the respondent authorities in arriving at order of removal from service. For both the reasons as indicated above, the order of removal from service dated 24/10/16 as well as the resolution number so-and-so of the Executive Council of the University are set aside as the interference is made on a technical aspect that the required procedure has not been followed. It is provided that the interest of justice should be met if the respondent university now proceeds against the petitioner from the stage where the deviation from the established procedure had taken place. Accordingly, the university shall give a consideration to the reply of the petitioner submitted against the show cause notice at 5/7/16 and arrive at a reasoned conclusion as to why the reply should not be accepted, and thereafter proceed with the requirement of the proviso to Article 32(6) of the Ordinance of 2000. It is clarified that the implication of the order of removal being set aside is that the petitioner stands reinstated in service, and thereafter the authorities can proceed against the petitioner as per law. We were required to take up only two procedural parts after the judgment of this honorable court. Therefore, my lord, whatever had happened in the inquiry, not being challenged, not being interfered with by this honorable court, my lord, that part has attained final. Now, what remained for us to do was give the petitioner an opportunity to show cause and to consider the reply before we came to a conclusion regarding her guilt. On the next page, lordship will find at page 239. This, my lord, is again the minutes of the special meeting of the Executive Council held on 23rd April 2018. Item number 1, lordship will find at page 240, my lord, just above the discussion paragraph, 2 paragraphs above the discussion.
Yes.
However, so and so approached the Honorable Guwahati High Court by WPC number so and so, which was disposed of by judgment and order dated 23/18, directing the university to consider the reply representation dated 18/8/16, submitted by the writ petitioner as against the inquiry report dated 28/12/15 to arrive at a reasoned conclusion, and thereafter proceed with the requirement of Article 32(6). It was also brought to notice that the Honorable Court had clarified that by implication of the orders passed, the petitioner stands reinstated. It was noticed that the charge officer has not reported to the university till date, even after disposal of the writ petition preferred by her. Now, this is an order of my lord 23rd of April 2018. I'm sorry, my lord, 23rd of April 2018, whereas the judgment was of 28th of March 2018 for nearly 1 month after being reinstated by the Honorable High Court, my lord. The petitioner had not reported, and therefore we proceeded.
Yes.
Now, my lord, lordship will find the discussion part. In the discussion part, my lord, I will little positive time, my lord, I will not go through each of the sentences, but lordship will find discussion. Lordships write the charge sheet. Lordship will find charge number 1. Charge number 1 is noted. The inquiry committee had returned a finding that there was no basis for the aforesaid work. Next paragraph, on a consideration of the representation of the charged officer. Now, the representation is taken into account. What was not done on the earlier occasion. Now we do it. Then lordship will find at page 241. The second paragraph from the top starts with the word the Executive Council notices. That paragraph ends. Thus, the Executive Council is of the unanimous opinion that the charge number 1 against the charge officer stands proved. Thereafter, we have my lord charge number 2 and 3, which were found to be proved. Then we have charge number 4 and 5. On the next page, my lord, at 242, they are found to be proved. Charge number 6 and 7, page 243, found to be proved. Charge number 8, proved. Charge number 9, on the next page, proved. Charge number 10, on the next page, is also opined to be proved by the Executive Council. Lordship may also note that this is not a decision that is being taken by a one-man committee. It is the Executive Council of the University, which is discussing. Had time permitted, my lord, I would have gone through each of the discussions to show how.
There's no harm.
My lord, then I will go. My lord. Charge number 1, my lord, page 240, I will read. Charge number 1. The first charge primarily against the charged officer was that she had dishonestly and without sanction from the competent authority allotted 2 numbers of earth filling work related to development and raising of land of proposed construction of hostel building. The inquiry committee had returned a finding that there was no basis for the aforesaid work having been allotted to the 2 contractors. The absence of the regular and normal procedure of inviting tenders as given in clause 34(3) of the first statute of the university, preparation of comparative statements, selection of particular allottee after opening due approval was given a go-by while issuing the work order. The first charge was opined by the inquiry committee to have been proved and established. On a consideration of the representation of the charged officer against the findings of the inquiring committee, it is noticed that the charged officer has contended that after approval of the estimates of the 2 works under reference by the Planning and Construction Board, no further guidelines for execution of works were issued. It was further contended by the charged officer that there was no decision of the Planning and Construction Board due that APWD code should be followed for contract works. She has also contended that works were carried out on verbal orders of the Vice Chancellor due to paucity of time to ensure utilization of government funds. She has also contended that the word earth filling supply was a supply work and not a construction work, and hence she did not resort to tender process. The Executive Council notices that the charged officer has admitted that the established procedure in the Dibrugarh University is to invite tender of all approved work and allot the works to the lowest tenderer based on the comparative statement. There was no question of providing any extra guideline to execute the work, as the university engineer DU, being the leading technical person controlling and planning the construction branch, was well versed in performing similar kinds of work. As per records, the charge officer has submitted a representation on 5/8/2016 against the inquiry report, wherein she has also annexed certain documents. As per the said documents, the Honorable Vice Chancellor DU had directed the university engineer to convene a meeting of the Planning and Construction Board DU for utilization of government fund on 6/5/2010 itself. In the absence of such a meeting being convened, the delay referred to by the charged officer was her own creation, which was possibly to create a situation of emergency at the fag end of the fiscal year. It becomes clear from the description of the specification of the item that the item of work include the labor part, that is breaking of cloths, leveling and dressing, etc. And so it is a composite work and not supply work. The charged officer in the capacity of the university engineer DU herself signed the work order. It is thus noticed that the charge officer did not follow the tender process while allotting the 2 work orders and acting beyond her authority, allotted work without sanction from the appropriate authority. Thus, the Executive Council is of the unanimous opinion that the charge number 1 against the charged officer stands proved. It is not the case of the repetitioner, my lord, that what has been discussed in her representation has not been taken into account by the Executive Council. The Executive Council has gone through every of her defense as relates to charge 1 and has held it to be proved. Charge number 2, it is noticed that these 2 charges were considered together by the inquiry committee, and the charge officer has also filed a consolidated reply. The 2 charges taken together are to the effect that the work order valuing a cumulative amount of rupees 33,79,300 was allotted to 2 contractors without inviting tenders and at the preference of the charged officer, violating the due procedure of allotment of contract work related to earth filling work. The inquiry committee had returned a finding that as per evidence of the charged officer, the 2 contractors had informed her that the Vice Chancellor had asked the 2 contractors to execute the earth filling work, and by going by their version, she had allotted the earth filling works to the said contractors. The charged officer has admitted that the tenderer system was not followed, though she had contended paucity of time as the reason. The inquiry committee has opined that the tender process could have saved considerable amount of public money. This was the opinion of the inquiry committee. The charged officer has contended that the planning and construction board has approved the work. This is in her reply to her representation. Approved the work estimate, and that once the vice chancellor selected contractors to execute the earth filling work, she could not object the same. She has also contended that though the work orders were sent to the vice chancellor and the registrar regarding the work in issue, they were not sent back asking the university engineer to invite tender. She has contended that if she is found liable, then all the members of PNC board and the vice chancellor should also be equally liable. The Executive Council notices that the plea of the charge officer regarding the vice chancellor in selecting contractor to execute earth filling work is baseless. The charge officer admittedly did not know the tender process, and her plea of paucity of time did not follow the tender process, and her plea of paucity of time is also baseless since estimate was approved on 8th day of March 2011 and work orders were issued on 21st day of March 2011, leaving enough time for her to call for tenders. The reference to the work order being sent to the vice chancellor and registrar are irrelevant when the charged officer has admitted that the due process was not followed. On a consideration of the entire circumstances, it is concluded that the charged officer has acted illegally when she deviated from the established procedure to allot work to 2 contractors without following tender system, and thus the charge number 2 and 3 are found proved. Charge number 4 and 5. These 2 charges have been considered together by the inquiry committee. The charges are that the work order issued by the charged officer as supply items is totally illegal and unjustified, and the same was done with ulterior motive for wrongful gain of the charged officer and to cause wrongful loss to the university. Further, the record to the measurement book shows that the works were executed as composite item of earthwork and not as a supply item. The work orders were issued with the permission of proper authority and by exceeding the charged officer's jurisdiction. The inquiry committee found that the nature of the works was clearly composite and not supply work, and that the measurement books revealed that the work was executed as composite earth filling work. The charged officer has admitted that the work is composite work and the work was done haphazardly and there could be some irregularities. The charged officer admitted that the full amount quoted as per estimate was entirely paid without ascertaining the volume of work executed by taking profile measurement. The charged officer admitted that the estimates were prepared without knowing the exact site of construction. The 2 charges were found to have been proved by the inquiry committee. The charged officer in her reply to the inquiry report has contended paucity of time as a reason for ordering the artwork as supply work, and that there was alteration of site of construction. She has further stated that copy of work orders sent to the vice chancellor and the registrar were not sent back to her. She has also contended that the direction of the vice chancellor had to be followed for the sake of the university. She has also stated that it was not possible to take profile measurement as the area was muddy. She has contended that there was no decision to follow APWD code. The Executive Council finds that there is no available record regarding alteration of site for construction of hostel building. A charged officer has admitted that the work order was issued as composite work, but while approving payment, it was paid as supply work. The Executive Council is of the opinion that difficulty in profile measurement as cited by the charged officer was never informed to the authorities. The act of her releasing payment purely on assumption and faith on the contractor is wholly unacceptable. It is also observed that the practice of following APW code was in the knowledge of the charged officer since she had on earlier occasions followed the APWD code, and the 2 work orders in issue were also issued taking APWD rates. Thus, charges at charge number 4 and 5 in the opinion of the Executive Council are proved. My lord, if I pause here for a moment, there was some earth filling work. Trucks were brought in with earth. The amount of earth being filled up is not being checked, saying it is muddy. Payments are being made. When the work comes in as a composite work, process is a bit long. When the payments are made for supply, it is a mere counting and payment. There is not much difficulty. So the payments are made as supply, so that there is no hassle of all the measurements being taken. It is made as a supply. That was one of the charges. That is where the university suffered loss. Now, let's charge number 6 and 7. These 2 charges have again been considered together by the inquiry committee. The charges were to the effect that the measurement given by the charged officer were not supported by field book or level book, and that such book were not enclosed only to cover up the illegal actions as earth filling was not completed as per order. It was further alleged that the undue haste in approving bills submitted by the contractor indicated ulterior motive. It was alleged that the work was not supervised and the work was not completed as required by the work order. The inquiry committee found that the work orders were issued on 21/3/2011 and the final bills were prepared and submitted by the charged officer on 29/3/2011. The charged officer has stated in her evidence that even prior to issuance of work order, the contractors were given verbal order to start the earth filling work since it took 20 to 30 days practically to complete the earth filling work. The inquiry committee found the charged officer's contention that no agreement or security deposit was undertaken from the contractor since the work was considered as of supply nature to be absolutely absurd. The committee took note of the contention of the charged officer that she was unaware of any such books, namely level book and field book. One of the contractors has also stated that it took about 40 to 45 days to complete the work. It was also noticed by the inquiry committee that the charge officer had not contended that the vice chancellor had issued verbal order in her presence to execute the earth filling work. The contradiction in the evidence of the defense witness has also been observed by the inquiry committee. The charge officer stated that the field books and level books were not supplied by the university authorities. She further contended that since it was supply work, recording of work at the beginning and at completion does not arise. She further contended that it was a matter of common sense. Without filling and developing a 6 feet deep area, the contractor cannot gather the building materials like brick, rod, sand, etc. The executive council is of the opinion that the charge officer has admitted that the work was executed haphazardly and there were some irregularities in execution of the work and also approving payment to contractors. Though she referred to counting of trucks and truck measurement, she did not produce any records before the inquiry committee. It is further observed that the measurement book issued for works can be used for recording level measurement, and by recording the initial level first in the measurement book before earth filling works and thereafter recording measurement during filling works, the filling level could be recorded. Her reference to verbal order of vice chancellor is unsubstantiated. The deviation from the reasonable procedure of measurement has paved way for full payment on certificate of charge official when work remained incomplete. This, in the opinion of the executive council, was to cause unlawful gain to the contractor and the charge officer and to cause lawful loss to the university. Charges 6 and 7 in the unanimous opinion of the executive council stand proved. This charge related to the allegation of violation of duty by the charged officer when she deliberately failed and neglected to deduct 12.5% shrinkage volume of the earthwork from the quantity of earthwork in the measurement book, even though the work orders referred to such deduction, thereby causing financial loss to the university. The further allegation was that the undue haste in approving the bill without deduction indicated ill motive for wrongful gain to herself and to cause wrongful loss to the university. This 12% deduction of shrinkage volume, that what I was given to understand was when we do earth filling work, once the earth is filled up, it shrinks. Thereby, where we need a certain volume, although on the initial stages it appears to be that volume, once it shrinks, that is gone. So what is done is a 12.5% of the total volume shrinkage is retained with the university. If it does not shrink or is made up after the shrinkage, this 12.5% is released. What the petitioner did was she did not deduct that 12.5% and gave full payment of the amount to the contractors. The inquiry committee has found that there was no dispute that the 12.5% shrinkage volume was not deducted from the final bills, and this has also been admitted by the charged officer. The charged officer has also admitted that due to failure to deduct the shrinkage charge, an excess of rupees 4,22,412 was paid to the contractor. This charge was held proved. The charged officer in her reply has stated the deduction of shrinkage volume was not done due to critical condition of site. She again referred to truck measurement, alleging that since the site was a paddy field area, neither leveling was done nor materials were stacked. It is noticed by the executive council that during the inquiry, the charged officer has contended that shrinkage was not deducted because after 3 years of completion of the work at the time of opening of the building, when the area was found to have shrunk, the contractor had filled up the surface and brought to required level at their own cost. The charged officer has changed her stand in her reply to the inquiry report. The fact remains that 12% 12.5% shrinkage volume was not deducted from the final bills, even though the work order had specified so. As admitted by the charged officer, the bills were passed without requisite deduction, and thus the Executive Council is of the opinion that the charge number 8 stands proved. Though charge number 9 and 10 were taken up together by the inquiry committee, the Executive Council decided to take up the charges individually. The charge number 9 was that the charged officer failed and neglected to perform duty when she approved the work as final and completed, though it was later found that artwork was not done as per measurement in the measurement book and work was yet to be completed. It was also alleged that by allowing bills to be passed, she caused wrongful financial loss to the university and brought wrongful gain to herself. The inquiry committee had opined the charge officer conducted herself very casually and perfunctorily in the discharge of her duties. In her reply to the inquiry report referred to she referred to alleged verbal orders of the vice chancellor to start art filling works. She also referred to other bills and other work order and has alleged malafide against the former vice chancellor and 2 officials. The Executive Council finds that there is no proof of verbal instruction of Vice Chancellor regarding the works it issued. It is further noticed that the charged officer did not, as she could not, deny that work order were issued without following the due process of law, that there was lack of supervision and maintenance of measurement records on her part, and that bills were approved and passed even without conforming to the standard deduction mentioned in the work orders. It is also noticed that on mere approval of estimates, work order were issued and payments were made in haste after creating an illusion of paucity of time to utilize government funds. The Executive Council, after taking note of the entire evidences on record, the opinion of the inquiry committee, the reply of the charged officer to the inquiry report is of the considered opinion that the charged official acted illegally in the entire transactions, from the stage of issuing work order without following tender process to the stage of passing bills without being completed, including not maintaining records during alleged execution of art filling works. Charge number 9 stands proved. Charge number 10, this charge alleged violation of Dibrugarh University Financial Rules 1972. It was alleged that the charged officer failed to exercise vigilance in respect of expenditure incurred from the university fund, as could be expected of a person of ordinary prudence to exercise in spending his own money. The inquiry committee, while considering the charge along with charge number 9, had observed that there was no doubt that the charged officer had failed to maintain discipline, absolute integrity, honesty, and sincerity and devotion to her duties. Contention of the charged officer in a reply to the inquiry report has been perused. The Executive Council, on consideration of the manner in which the work orders were issued, final bills were approved without following tender process and without maintaining records, is of the opinion that there remains no iota of doubt that the charged officer had failed to exercise the vigilance expected of person of ordinary prudence in the entire transactions relating to the 2 works in issue. She had failed to maintain discipline, sincerity, and devotion, and her acts do not inspire confidence that she had acted in absolute integrity and honesty. The charge number 10 is also a point to be proved by the Executive Council. The Executive Council notices that apart from providing replies charge-wise, the charge officer has also raised other grounds with regard to the proceedings of the inquiry. On a perusal, it is seen that the ground number 1, 2, 9, 10, 11, 12, 13, and 14 under the caption conclusions are rather vague and have been forwarded only to be rejected, since there are no basis for the said grounds. With regard to ground number 3, the charge officer has referred to the absence of evidence of Dr. K.K. Deka, who was the then Vice Chancellor of the university. The council opines that the charged officer could have well brought in Dr. K.K. Deka as a witness, in case she felt so the need. There are no records of any request made by the charged officer. The ground number 4 and 5 are with regard to the evidence of the university registrar and assistant university registrar. The council opines that the evidence of the registrar and the assistant university engineer has been crucial and there is no illegality in taking their evidence. With regard to ground number 6, the charged officer refers to the appointment of a legal practitioner as one of the members of the inquiry committee, and where she claims that she was not given a legal practitioner as a defense representative. The council considers the said ground to be irrational. There are no records to show that the charged officer has sought for the assistance of a legal practitioner. Since the presenting officer on behalf of the disciplinary authority was not a legal practitioner, no prejudice has been caused to the charged officer. Her references at ground number 7 and 8 relating to the list of witnesses and joinder, misjoinder, and non-joinder parties are also found to be baseless apart from being fake. it is noticed that the charged officer has attempted to mislead by her reference to the case of Agarwal versus HSDC. While the said case referred to a situation when presenting officer was a man trained in law, the charged officer had tried to project it relating to be that to a presiding officer. Discussion. The council discussed the gravity of the offences proved against the charged officer and concluded that since honesty, integrity, and devotion to duty of the charged officer is in question, the penalty has to commensurate with the gravity of the offence. It is further noticed that it would not be in the interest of the university to allow the charged officer to continue her services at the university. On going through the inquiry proceedings, the council has found that the inquiry has been held according to the ordinance and orders. The charged officer was given opportunity for defense at all stages. The inquiry committee had conducted the inquiry keeping in view the principles of natural justice, and on completing the inquiry in accordance with the rules, the committee gave ample opportunity to the accused to prove her innocence. During the inquiry, accused admit to utilizing all opportunities on considering the circumstances and the facts upon applying the mind in a judicious mind. The Executive Council have no hesitation in holding Srimati so-and-so guilty of the charges leveled against her based on all connected documents, including the replies furnished by the charged officer. Therefore, the Executive Council is of the opinion that she, having committed the offences that she was charged with, an appropriate punishment in terms of the offences is to be imposed. Decision. Resolved that the charged officer stands reinstated as per clarification given in the order of the Honorable Court. Further resolved that the method and manner of regularizing the period of her absence from duty shall be considered at the time of passing of final orders on the departmental proceeding. Resolution number 2. Resolved that upon a thorough consideration of the charges imputed, the evidence led, the report of the inquiry committee, and the reply thereto furnished by the charged officer, the Executive Council is of the unanimous conclusion that all the charges imputed against the charged officer are proved, and accordingly appropriate penalty is to be imposed upon her. Next discussion. The Executive Council, while considering the gravity of the offence and the quantum of punishment, was of the opinion that if the guilty person with such a dishonest mentality is not punished, keeping in view the palpable misconduct of not following the established procedure, causing financial loss to the university, then it may have an adverse effect on other persons and system of working in the university. It was further a consensus view that her retention in service would not be in the interest of the university. Therefore, the Executive Council unanimously agreed that the penalty of removal from service would suffice the cause. Resolution number 3. Resolved that the Executive Council proposes to impose the penalty of removal from service upon the charged officer as per Article 32(6)(h) of the Ordinance of 2000 as amended. The Registrar of the University is to accordingly arrange for compliance of the provisions of proviso to Article 32(6), so as to convey the proposal of the council to impose the penalty of removal from service upon the charged officer to the charged officer, requiring her to submit her response to such proposal, giving her not less than 3 weeks time from the date of receipt of notice. Thereafter, my lord, the item number 2, item number 3 are not relevant to the present case. Now, here, what I would emphasize is, my lord, each of the grounds taken by the petitioner against the inquiry report was taken into consideration, and it was resolved that she was found to be guilty. It is not the case, my lord, where her replies to the inquiry officer's finding, my lord, was not taken into consideration. They were taken into consideration.
Was she given a notice under Article 32(6)?
Yes, my lord. Now, lordship will find it page 200 to page 247. She has given a representation, and lordship will find it page 248. I'm sorry, my lord.
251.
251. Number 249. Lordship will find page 249. my lord.
Yes.
This is to the petitioner from the office of the registrar. Notice as per proviso to Article 32(6) of the DU Employees Service Condition Ordinance 2000 as amended. I am under instruction to inform you that a special meeting of the Executive Council DU was held on so-and-so, whereupon the order dated so-and-so passed by the Honorable High Court was perused and consequent action was taken. It has been duly noted that as a consequence of the orders passed by the Honorable Court, you stood reinstated in service, and it was duly noted you have not reported to the university after disposal of WPC number so-and-so preferred by you. Then Lordship will come to the last paragraph, my lord. Your attention is drawn to provisions to proviso to Article 32(6) of the Ordinance 2000, and you should submit your reply to the show cause notice within 22 days of receipt of this notice. Just the paragraph before that. You are therefore now called upon to show cause as to why the proposed penalty of removal from service should not be imposed upon you. Copy of the extract of the relevant portion of the minutes of the special meeting and the discussion prior to adoption of resolution number 3 and resolution number 3 are adopted in the meeting are enclosed herein for your use. That Lordship will find at page 250. She makes a reply at page 251, which continues, my lord, up to page 264. My lord, what the requirement of a reply was to state as to why the punishment of removal from service was not to be imposed upon her. This reply, my lord, if we go through paragraph to paragraph, we'll find that she has still continued to find faults with the inquiry itself. That stage was already over the moment she was held to be guilty by the Executive Council. Now she was required to reply why that particular punishment should not be imposed upon her. She goes on to challenge the other, to assail the entire disciplinary proceedings again, and my lordship will find that at page 264, para 10, that I reiterate that your present move to remove me without a semblance of compliance to rules and without conforming to the purpose and protections guaranteed by the ordinance regulation has caused great injustice to me, even assuming that the findings of alleged guilt or proof of charges against me as recorded by the inquiry committee are acceptable by the disciplinary authority. It is not understood to why the recommendation of the same inquiry committee as regards your action against higher officials and administrative reform have not been accepted or even considered. Accordingly, punishment proposed against me being manifestly unreasonable and arbitrary may not be imposed upon me. Hence, it is humbly prayed that considering the aforesaid facts and circumstances, charges leveled against me be kindly dropped. Charges be dropped, and I may be exonerated from all the charges, and further I may be allowed to continue as university engineer for the Dibrugarh University and applied. This matter is taken up at page 265 by the Executive Council again. Where my lord, at item number 5 on 16th of March. What is wrongly? Deeply wrong missing. Oh, this should not be 2018, my lord. It had to be 2000. Date I'll clarify, my lord. Now, lordship will find at item number 5 to consider the written reply representation dated 18/6/2018, erroneously dated as 18/6/2018, and Dibrugarh University received letter on 18/5/2018, submitted by the Srimati Dipali Fukan, University Engineer, against the letter dated 27/4/18 of the registrar. Based upon such written reply, the Executive Council is to take a decision for imposing appropriate penalty as per Dibrugarh University Employees Service Conditions upon the University Engineer. The reply filed by so-and-so University Engineer, Dibrugarh University, on 18/5/18 to the notice dated 27/4/18 issued by the registrar, Dibrugarh University, conveying the resolutions of the Executive Council adopted on 23/4/18 has been perused by the members of the Executive Council, Dibrugarh University. Copies of the same have been forwarded earlier to all the members of the Executive Council for perusal and consideration. It has been observed that the charged officer has based her representation on the merits of her defense taken during the inquiry proceedings and has raised grievances regarding the finding of guilt by referring to evidence led during the inquiry proceedings. She has, however, also stated that she had been performing her duties with utmost sincerity and honesty, and that she had not flouted any norm or prevailing procedure of the university. She has further reasoned that the decision to impose the penalties without due application of mind and without any basis. She has further reasoned that the proposed penalty is manifestly unreasonable and arbitrary, and as such the same may not be imposed upon her. The representation of the charged official has been duly considered by each of the members of the Executive Council. The earlier resolutions of the meeting of the Executive Council held on 23/4/18 have also been perused. Though the allegations and support sought to be drawn by the charged officer insofar as they relate to the inquiry proceedings and the finding of guilt do not require a reconsideration, since only the issue to be determined is the nature and quantum of penalty required to be imposed upon her. Yet the Executive Council of the Dibrugarh University has, in light of the issues raised by the charged officer, also deliberated on the issues raised by her. The evidence laid during the inquiry proceedings by both the parties have already received the attention and consideration of the Executive Council, Dibrugarh University, and specific findings have been recorded after due evaluation. Each of the charges has been found to be duly proved. Assertion of the charged officer that the resolution to impose punishment on her is absolutely mechanical, manifestly preconceived, and is without reason is not true. Her prayer for dropping of charges and exonerating her does not have merit because at this stage, the quantum of penalties under consideration she has already been found to be guilty of the charges leveled against her. Thus, taking into consideration the nature and gravity of the charges proved against the charged officer and also taking into consideration the representation filed on 18/5/18 by the charged officer in reply to the notice dated 27/4/18, the Executive Council University has observed that the charged officer has lost the trust and confidence reposed upon her, and also keeping in view the gravity of charges proved against her, and consequently, the Executive Council Dibrugarh University unanimously resolves that strict and exemplary penalty is required to be imposed upon Sri so-and-so. Therefore, in excess of powers conferred by the University Ordinance 2000, the Executive Council resolved to impose the penalty of removal from service upon Srimati so-and-so with immediate effect from 4/6/2018. The registrar of the university shall take immediate steps to serve a copy of this resolution and order upon Srimati so-and-so. It has been brought to the notice of the Executive Council that although the Honorable Court had deemed the charge officer to have been reinstated in service by order dated 28/3/18, the charged officer has not reported to the university till 2/5/2018, and that was after she received the letter dated 27/4/18 issued by the registrar of the university. The council observes that the earlier order imposing penalty were set aside on the ground of non-adherence to procedure, namely failure to record detailed reasons on finding of guilt and failure to offer opportunity of show cause on the quantum of penalty. Since the delinquent officer reported to the university only on 2/5/18, she would be entitled to pay for the period from 2/5/18 to 4/6/18. She would not be entitled to any pay for the period from the date of her removal from service, that is 24/10/16 to 1/5/18. On the principles of no work, no pay, the period of absence required to be treated as dies non, the registrar shall take action accordingly to disburse the dues, if any, to her. Decision: resolved that upon consideration of the reply furnished by so-and-so university to the proposed penalty of removal from service, the Executive Council decides to impose the penalty as proposed, namely removal from service with immediate effect. Resolution number 27, resolved that so-and-so shall not be entitled to any pay or allowances for the period from 24/10/16 to 1/5/18 on the principles of no work, no pay. She would be entitled for salary only for the period from 2/5/18 to 4/6/18. Period of her absence shall be treated as dies non. Thereafter, my lord, she was relieved by the orders on the next page. And that is, those are the orders, my lord, now which are under challenge in this petition.
Thank you. What date is this?
My lord, that was on 4/6/2018, my lord. The final orders, my lord, the final resolution.
Oh.
It is on 4/6/18, my lord. There's some typographical error apparently. At the top, my lord, is a typographical error apparently. Signatures are of 4/6/18 and the orders have been made effective from 4/6/18.
Order came out the same day.
Same day, my lord. Executive Council passed the order and the registrar published it, my lord.
Yes.
My lord, one thing that the petitioner has done is that, my lord, she has also filed an appeal as provided under the rules ordinances, which is pending before the Honorable the Governor, my lord. And pendency of that appeal, she has approached this Honorable Court
Who's the appeal?
in a repetition of that she has admitted. If Lordship would have her affidavit in reply. At running page 291, perhaps, my lord. Page 5 of the affidavit in reply, otherwise.
Reply affidavit.
Affidavit in reply, my lord, yes. Probably filed on. The running page would be, my lord, 291. At page 60, para 16, Lordship. Regarding the statements made in paragraph 33 and 34 of the affidavit, the humble deponent begs to state that against the impugned action and order dated 4/6/2018, issued by the Registrar of Dibrugarh University, she submitted her 16. Page 291, my lord.
This is affidavit in opposition.
My lord, affidavit in reply, I refer.
11/9/19, my lord, I have filed. 11/9/19.
Yes. That is 278 here.
I'm sorry, my lord, there's some mistake in
Yes.
my continuation, I'm sorry. Para 16, my lord.
Oh.
That regarding the statements made in paragraph 30 and 34 of the affidavit, the humble deponent begs to state that against the impugned action and the order dated 4/6/18 issued by the Registrar of Dibrugarh University, she submitted her statutory appeal before the Honorable Chancellor of Dibrugarh University on 19/6/18. Thereafter, the Joint Secretary of the Governor's Secretary addressed a letter dated 6/8/18 contained under memo number so-and-so to the respondent number 3 inter alia, requesting him to examine the matter and submit parawise report for onward submission to the Honorable Governor of Assam and Chancellor of Dibrugarh University. Copy of the said letter was also furnished to the humble deponent to know the progress of the matter. Learned advocate on behalf of so-and-so, so-and-so. The writ petition, Lordship will find, was filed in September 2018. Now, my lord, one situation that I can think of. The appeal is dismissed and the writ petition is allowed. There is a contradiction. The appeal is allowed, yet the writ petition is dismissed. There will be another contradiction. So, one forum at a time is the law that I understand. The appeal having been preferred earlier, a writ petition asking for an early disposal of the appeal is what I would have understood, my lord. Same grounds, two forums will not be, and the forum which is approached at an earlier point of time, my humble submission, my lord, that should be retained. In that view, my lord, this writ petition at this stage may not be maintainable, may be a bit premature, unless the order, either the appeal is withdrawn or an order is passed on that. Now, this appeal is brought to the notice of this honorable court only after we file our affidavit in opposition. It is not brought to notice in the writ petition, if I am not wrong, my lord. That is one part of it. Now, my lord, to maintain a writ petition against a disciplinary proceeding, Honorable Supreme Court has laid down certain parameters in which it can be done, my lord. Those judgments I have, my lord, if
You can conclude in
my lord?
5 minutes. Oh.
Well, those judgments I'll have to refer and I'll just come down to the point, my lord. So, referring to the judgments may require a little more time. 5 minutes may be too short.
Mr. Nuts.
I think at least I'll take 5-7 minutes. So, Lordship will take.
Then we'll fix a date.
My lord, yes, because now
Yes, because
all I have to do
otherwise,
is, my lord, refer to the judgments to bring my a conclusion to my.
but we have almost come to the conclusion
Yes.
part, my lord.
But Mr. M. Nutt, Learned Senior Counsel, assisted by
DJ Kapil Lordship.
DJ Kapil,
DJ Kapil, Learned Counsel for the.
DJ Kapil, my lord.
Also heard Mr. R. Majumdar, the standing council, Delivery. 13 parts. Please for the hearing again on, I fix one single bench matter, no? That will be too far off it.
Yes, my lord, because it is easy, better for your lordships also. You will release it closer dates.
Both of us together will not take more than 15-20 minutes, maybe half an hour at the most.
Yes.
11th.
My lord. My lord. 11th. 11th, please. 11th, 16th. My lord, can it be 16th, my lord? 16th. Obliged. Obliged, my lord.